Would Ms. Jones, would you please do the roll call for attendance?
Yes. Hang on, I gotta be someplace by a microphone, don't I? Not the handheld. All right, so we got everybody else with mic set. Hello, hello. Hello, hello. Okay, there we go. Okay. Member Bitzer, are you present?
Yes.
I see you. Can you speak up, Mr. Bitzer? Unmute yourself.
Could it be because I'm unverified? I'm talking. Does anyone hear me?
Okay. Try
Yes.
again.
Yes, I'm present.
Yeah, I've got him unmuted. Okay, well, we're gonna let you figure out how to unmute yourself. I see you. Member Ely,
Present.
Member Garcia,
Here.
Member Honker,
Present.
Vice Chair Trujillo. Vice Chair Trujillo, I see you're in the meeting. Okay, Chair Sweeney.
Present.
Thank you. Let's try Mr. Bitzer. Did you get yourself unmuted yet?
It's not my problem. The problem is at your end.
On our end.
I show him as being unmuted. He's emphatically pointing at us, so maybe I feel so accused. And I see Vice Chair Trujillo. Come on, you guys, not today.
It's not us.
Hearing officer, I see them both. Can we assume that they're present?
Present here.
Okay, and we'll work on their audio. Mr. Bitzer's giving us a thumbs up, so. Okay.
We have to hear on the count.
Okay, I see them and they are on the meeting and you've got yourself a quorum.
So everyone on WebEx is able to hear Mr. Spitzer.
Yeah.
We're just not able to hear in the.
Can we do a sound check with everyone online? Somebody other than Mr. Bitzer tell us that you can hear us?
I can hear you. This is Kathy.
Okay, thank you. Thank you, Ms. Grimm. Mr. Bitzer, can you try to say something? Just in the event you want to jump in.
Test drive, 1, 2, 3, test.
Gotcha. We hear you now. Thank you. Vice Chair Trujillo, can you say something to us?
Vice Chair Trujillo, can you
Hello? Can you
do a sound check for us?
okay?
Yes. Okay, we hear you.
Can you hear me now? Okay.
All right, can we turn the volume up on these guys?
You want them speaking together?
Testing 1, 2, 3. Testing 1, 2, 3.
Cheryl, can you hear me? Okay. Louder? I can get really loud. Okay.
Ms. Jones, would you please do the roll call one more time, just so we have it for the record?
I will. Member Bitzer, are you present?
I am indeed present.
And I can hear you this time. Thank you. Member Ely?
Present.
Thank you. Member Garcia?
Here.
Member Honker?
Present?
Vice Chair Trujillo?
Here.
Okay, get real close to your microphone so we can hear you. Chair Sweeney?
Here.
All right, everybody's present.
Thank you, Ms. Jones. With that, we'll go.
Try that again.
Thank you, Ms. Jones.
It's fun. He's working on it, Cheryl. Stand by.
With that, approval 7 agenda. Member Garcia. Member Hunker.
One question before we, I think we, okay, I see, that's, well, actually, I think we received the April 5th meeting minutes as well. February 29th. So are we going to take action on both of those today? And if so, we should add the other ones.
Okay, let's keep on the agenda for this, and we'll just go forward with the approval for March 22nd, 2024. Oh, I see. Yeah, there was gonna, I think, can we have a second and then we'll enter discussion?
Okay, I will second the motion.
Thank you, Member Hunker. And then the points of discussion is that as part of the agenda item number 3, is that what I understand? That we only have on our agenda approval of March 22nd, 2024 regular meeting minutes, and you were questioning whether we need to add the other meeting minutes. Is that correct?
That's correct, because I believe we received a draft of the 5th meeting. So my question is, are we going to take action on both of them, in which case we should amend the agenda, but if we're just going to act on the March 22nd minutes, then agenda's fine. See Council nodding.
Okay. Okay. So with the guidance of our council, we can't add agenda topics at this point because of the process, the administrative process. So we can add that to our next meeting agenda.
Okay, then I'm good with the agenda. Yes.
Thank you. Is there any other comments? Okay. No. With that, we have a motion on the floor in a second to approve the June 27, 2024 agenda. Ms. Jones, would you please do a roll call vote?
I will. Member Bitzer, how do you vote on the agenda?
I vote yes.
Member Ely?
Yes.
Member Garcia?
Yes.
Member Honker?
Yes.
Vice Chair Trujillo?
Yes. Yes.
Thank you. Chair Sweeney,
Yes.
the motion passes.
Thank you, Ms. Jones. With that, we go on to agenda item number 3, which is the approval of March 22nd, 2024 regular meeting minutes. Do I have a motion? Yes, Member Garcia.
Reviewed the minutes and I move March 22nd regular.
Thank you, Member Garcia.
Second.
Thank you, Member Honker. with a motion and a second, is there any other discussion for virtual members? No? With that, Ms. Jones, would you please do a roll call vote on Member Garcia's motion to, and Member Hunker's second to approve the March 2022-2024 regular meeting minutes?
Yes. Member Bitzer, how do you vote on the minutes?
I vote yes.
Thank you. Member Ely,
Yes.
Member Garcia,
Yes.
Member Honker,
Yes.
Vice Chair Trujillo.
Yes.
Thank you. Chair Sweeney. The motion passes.
Thank you, Ms. Jones. With that, we go on to agenda item number 4, public comment, general comments not pertaining to meeting agenda items. Looking to our public and also on the screen to see if there's anybody that would like to make a comment. Okay. Ms. Jones, just checking with you if you've received any requests to make public comment.
I've received no requests for general public comment, Chair.
Thank you so much, Ms. Jones. And with that, we'll go on to, with no public comments, we will go on to agenda item number 5, which is EIB 2412, public hearing in the matter of proposed repeal and replacement of 20.2.71 NMAC operating permit emission fees and 20.2.75 NMAC construction permit fees. And so now we have council for a meeting. And at this point, I think I turn it over to our hearing officer as well.
Thank you, Madam Chair. We're now on the record in this matter. First item of business will be to identify and swear in interpreter. So Ms. O'Grady, if you will identify yourself and your associates, we'll proceed with that item.
Good morning, Chair. Lisa O'Grady, Logar Interpreting and Translating LLC. Sorry, it sounds like it's cutting out. The interpreters this morning for Spanish are Dinora Gutierrez and Amelia Cardena. Navajo interpreters Esther Yazzie Lewis and Casey Watchman. ASL interpreters Kim Corwin and Santana. I apologize. I will get her last name for the court reporter in a minute.
Chavez is the last name, Lisa.
And Madam Court Reporter, would you like to swear them in?
Can the interpreters acknowledge that they've been sworn?
If you were speaking, we did not hear you. I'm sorry.
If interpreters would please raise their right hand. Do you and each of you solemnly swear or affirm that you will truly and accurately translate the following proceedings from English into the language that you are here to interpret for, and vice versa, to the best of your ability?
Santana Chavez, I do.
Kim Corwin, I do.
I heard two of you.
I have one other interpreter that has acknowledged being sworn in. Please acknowledge your swearing. She's not hearing us. Would it be advisable to take a witches or one of the interpreters is not hearing us? Let's go off the record and we'll just break in place here for a minute.
Yeah, and then sign in, have to do your email, that's what she had to do. Oh, okay. She had been in it for some, which it may take you a moment.
Thank you. Thank you.
We can hear you in the meeting room. Dinara, can you go on the English channel? Mr. Watchman, can you go on the English channel? Okay. And yes, so go back on the, let's finish with the swearing in. And Mr. Chair, we are still waiting for one of our Navajo interpreters to get connected. She's having difficulties. When she's on, we'll let the chair know. We have a Navajo interpreter that's on that can start to not hold up the proceeding. And once she comes in, we'll let the chair know.
Okay, we're going to swear in now each of the interpreters. You swear to tell the truth, the whole truth, and nothing but the truth. Two of them are holding their hands up. Not hearing from the other one is holding their hands up. So we have 3 interpreters sworn in at this point. 1 for Spanish, 1 for sign language, and 1 for Navajo. Okay, thank you. With that, I think we're ready to go. Hopefully we were on the record when that happened. On the record, Ms. Holguin. Okay, thank you. My name is Richard Virtue. I'm the hearing officer for this proceeding. For those who are participating by WebEx, if you have trouble, hopefully we won't have any more trouble. Sorry about that. For those participating by WebEx, if you have any trouble, please send a message to the chat room and do our best to deal with it. Hopefully we've resolved all of those problems at this point. Just for the record, we do have a quorum of the board members present. Same board members who are identified at the beginning of the meeting are still present. That would be Member Honker, Member Garcia, Member Ely, Member Bitzer, WebEx, Vice Chair Trujillo by WebEx, and Chair Sweeney is here. At this point, let's go to appearances of council. Who appears for the environment? And for the New Mexico Mining Association.
Good morning, Mr. Hearing Officer, Madam Chair, members of the board. My name is Dal Mullenberg. I'm with the law firm of Gallagher and Kennedy here in Santa Fe. Hearing on behalf of the New Mexico Mining Association, and with me is Samantha Catalano of our firm as well.
Thank you. For the Independent Petroleum Association.
Okay, Lewis Rose with Montgomery and Andrews for the Independent Petroleum Association of New Mexico.
Okay, and just for the record, we had a entry of appearance from a citizen, Nicholas Maxwell. He notified us yesterday he will not be in attendance today due to having to attend a funeral. I entered 2 procedural orders in this matter, which set forth the basic procedures that we're going to be following. I'm going to summarize very briefly the key points that are in those orders. We'll, in terms of the order of the presentations, we'll first have opening statements. All counsel have indicated that they would like to make an opening statement. Then we'll have presentation and cross-examination of petitioners, witnesses, both their direct and rebuttal. Petitioners have 4 witnesses. Then we'll have presentation, cross-examination, direct and rebuttal, technical testimony. from the Mining Association, followed by the same thing for the Petroleum Association. Once each witness has summarized their testimony, we'll have cross-examination, which will be in the order of Independent Petroleum Association first, New Mexico Mining Association second, petitioner third, and then we'll have any questions. I will ask any questions I have, and the board members may ask questions at any time during the proceeding that if a question comes up. I will also ask at the end of all the questioning of the parties if the board members have any questions. We'll go last, but feel free to ask questions if they come up as we're going through the testimony. I'm sorry about that. All right. We're going to have two sessions where testimony from the public, non-technical testimony from the public will be allowed. Those will be at 1 o'clock and at 5 p.m. I'm informed that we need to vacate this room by 5:30. So the second session may be shortened depending upon how many people have signed up. If the hearing continues tomorrow, which it looks like it will, we'll have sessions for public testimony at 1 o'clock. And then again at 5 if we're still here at that time. If members of the public would like to submit non-technical oral statements, you may sign up on the sign-up sheet, which is in a chair in the back of the room, or you may contact the WebEx host, and she will make a list of those people who wish to make public statements, and we'll call on you during that period of time. Public testimony will be limited to 3 minutes per person. It's my understanding that we don't have anyone who's signed up yet for public comment. Is that correct, Ms. Young? Okay. That most likely will change. We have 3 parties, as I mentioned, who have submitted statements of intent to submit technical testimony. Each of the witnesses for those parties will adopt their testimony under oath and be allowed 45 minutes to summarize their direct and rebuttal testimony, and then they will be subject to cross-examination. The hearing is being recorded on WebEx and being, transcribed by Cheryl O'Gean of our recording service. I intend to take one break in the morning of about 10 minutes, another break, 10 minutes, and break for lunch for approximately 1 hour around the noon hour. Each council, as I mentioned before, has indicated they would like to make an opening statement. And with that, we will turn to council for opening statements. Mr. Prinz, would you like to proceed?
Mr. Hearing Officer?
Yes.
There's one item I believe that had been identified as a procedural matter to address at the outset, and that is the motion from the Mining Association regarding the opportunity to do written closing arguments.
Yes, thank you for that reminder, Mr. Mullenberg. That will be taken up at the discretion of the board. I had identified it to be taken up at the conclusion of the hearing, but Madam Chair, is that acceptable?
That is acceptable.
Okay. So before we, at the conclusion of taking evidence, the board will take up that motion before adjournment of the hearing.
Fair enough. Sorry for the interruption.
Yeah.
I had understood that would be addressed up front.
Yeah. Okay, Mr. Prinz, you may proceed. Mr. Rose.
See if this works. Mr. Hearing Officer, just one point of clarification before we start. On looking at the public notice of this hearing, I had a question about whether or not the notice is subject to the State Rules Act. There's a notice provision in the Air Quality Control Act. And I think the notice meets that requirement. And looking at the State Rules Act, there's a requirement that the notice provide a citation to information or information supporting the requested rule change. And looking at the notice of this hearing, that the citation's not in the notice. And so I had a question of whether the board has decided whether the Rules Act notice provision applies or doesn't apply in this proceeding. If it does, I think we have a notice problem.
I'll defer to the board's counsel.
Good morning. It appears that the notice that was provided on the website, the original notice of the agenda, includes a link to the board's website, which includes all as well as citations and all the details.
Okay, so is it then your opinion that the notice does suffice under 14-5-5.2, particularly A7, which requires a citation to technical information, if any, that served as the basis for the proposed rule?
Yes.
Thank you, Mr. Hale, sir.
Okay, we will return to Mr. Prince for his opening statement.
Mr. Chair, I apologize for interrupting. On WebEx, they're not able to hear.
Okay, let's just, we'll just recess in place here for a minute.
Test. Test, test. Test, test. Santana, are you able to hear this?
This mic? Do we need to verify that so people can hear via WebEx or virtual attendees?
Test.
Okay, test. Our virtual attendees can hear me. Morning, everyone. Again,
Can the virtual attendees please confirm that you can hear? They
Yes,
can? Okay.
operator can hear
All right.
clear.
We'll proceed then, Mr. Prince.
okay, good morning again. Again, Michael Prince, appearing for the New Mexico Environment Department. We're here before the board on the petition to repeal and replace 20.2.71 and 22.75 NMAC for operating permit fees and construction fees. These permit fees are critical for the Air Quality Bureau as they are the primary mechanism through which the Bureau receives the funds it needs in order to carry out its important regulatory oversight and enforcement of the Air Quality Control Act and the. Okay, I'm sorry. I have to just kind of bend over there. Oh, okay. I'll also try to speak up. Sorry about that. Now that sounds a little better to myself as well. Okay, so these permit fees in 20.2.71 and 22.75 are critical for the Air Quality Bureau as they are the primary mechanism through which it receives the funds it needs to carry out its important regulatory oversight and enforcement of the Air Quality Control Act and the Federal Clean Air Act. Current fee schedule that's in place for the operating permit fees has last revised in 2004 with a minor revision in 2009, and the construction fees that are in place currently was last revised in 2003. So it's been about 20 years since there's been any major revision of these critical fees. Now, both Part 71 and 75 fees do have consumer price index adjustments. However, there has been considerable changes in the regulatory landscape, as well as changes on the operations of the ground, most notably in the oil and gas industry, that have meant that there has been a large increase in the workload, the volume, and complexity of permitting applications, and the CPI increases have simply not been sufficient to keep up with the department's original projections of the amount of time and labor that it would take to process, issue, and monitor air quality permits. As the board is aware, there's been a substantial increase in oil and gas production in the state. We're now the second largest producer in the country. And with this large increase, there has also been a commensurate increase in applications and all the work that goes into processing those applications that the Bureau has to statutorily do within tight time frames, as well as there's also been technological advances in the industry that have made applications more complex. There's added workload to the Bureau um, as well. Over the last 20 years, there's also been regulatory changes, both state and federal, that have been adopted, and this has impacted the Bureau and increased the Bureau's workload, but there has not been a commensurate increase in the Bureau staffing resources to administer the new regulatory requirements. Some of the new requirements are 40 CFR 60 subpart quad J, quad O, quad OA, 40 CFR 63 subpart quad Z, and the US EPA has just issued the new subpart quad O B and C, and this is going to again increase the amount of work and that has to be done to process and monitor permits. Of course, this board also 2 years ago adopted the new ozone precursor rule, which has, again, added more work to that needs to be done by the Bureau. And the Bureau is, of course, is closely monitoring air or ozone, ground level ozone levels right now in several counties, which unfortunately may be soon attaining non-attainment status, and that will require more work by the Bureau. So these changes in the regulatory landscape and the operations of the regulatory industry have pushed the Bureau's financial and human resources to the limits, and that's why it's coming before the board today on this petition. The proposed increases will correct the fee deficiencies and properly fund the Bureau so that we'll be able to provide high quality services to the regulated industries and still fully and effectively enforce the air quality regulations. The US EPA has supported or supports this the Bureau's proposed fee increase. And I know the Bureau is aware of its statutory authority to, under the Air Quality Control Act, to abate pollution. And the mechanism to that end is through a properly funded Air Quality Bureau. So for today's presentations, we'll first hear from Michelle Miano. She'll provide an overview of the Bureau and all the work that it does. She'll also address the need for the permit increase, and how the Bureau will be able to provide better services to the regulated industry and do its regulatory oversight. After Ms. Miano, Melinda Owens, permitting section chief, will provide testimony, and she'll explain or provide details about the permitting process, all the work that goes into that, and how the changes over the last 10 to 20 years have impacted the permitting bureau, or permitting section rather. We'll then hear from Mr. Eric Peters, Control Strategies Manager. He has been an air dispersion modeler for 26 years with the Bureau, and he will explain changes in the complexity to air modeling and the work that entails. And finally, we'll hear from Donna Indermont, the operations section chief, and she will provide an explanation of the Bureau's funding and describe the financial picture that the Bureau is facing. So that's all I have. And with that, I would call Michelle Miano this time to be sworn and provide testimony.
I'll have the other council make opening statements and then proceed with your testimony. Mr. Mullenberg.
Thank you, Mr. Hearing Officer, Madam Chair, members of the board. As indicated previously, my name's Dal Mullenberg, and I'm here with Ms. Catalano representing the New Mexico Mining Association in this proceeding. The basic position of the Mining Association is that the testimony provided by the department does not provide sufficient information for the board to assess the need for a fee increase or the amount of any fee increase. In our view, the department has provided a minimal amount of information, particularly quantifiable information, for the board to assess those needs. And I would add that the department's testimony omits key information from its testimony, such as the fact that unspent fee revenue has been accumulating in the two funds where fee revenue is first placed and then withdrawn when expenditures are made. The board's fee authority is under the Air Quality Act, and the board under that authority is to set a schedule of fees for two programs. One is the Title V permit program, or I think in some of the testimony referred as the Part 70 permit program, referring to Part 70 of the United States EPA rules that describes the Title V permit program. And the fee rules currently for that are in Part 71 of the board rules, or 20.2.71 NMAC. NMED is offering 3 witnesses today to present its position. NMED's first witness is Matt Thompson, who is the incoming executive director of the New Mexico Mining Association. NMED, I'm sorry. It's good that I have a bunch of people to correct me here. The incoming executive director of the New Mexico Mining Association. He's going to describe the Mining Association members' interests in this proceeding as permit holders who pay the fees. And we'll talk about the nature and importance of the mining industry in New Mexico and the potential impact of the high fees, particularly Title V permit fees that would be assessed if the board adopts the rules. The Mining Association also has 2 other witnesses, both of whom are employed by Freeport-McMoRan. The first is Sherry Burt-Kested, and she has provided both written direct testimony and written rebuttal testimony following a review of the NMED direct testimony. There's a number of points made in Ms. Burt-Kested's testimony. One important part of it relates to the basis NMED's testimony indicates for increasing the fees under Part 71 of NMAC. And in particular, Ms. Burt-Kested will point out why there cannot be a direct comparison of the per ton rate specified under EPA's presumptive fee level.
Mr. Miller, excuse me. It looks like we've lost the WebEx feed, so we'll have to recess in place here again for a moment. Okay, looks like it's back, so let's proceed.
Thank you, Mr. Hearing Officer. So I was explaining that Ms. Burt-Kested's testimony addresses the difference that the board should recognize if it's comparing the EPA presumptive per ton fee rate compared to the rate in Part 70, which are based on 2 different emissions rates. Ms. Burt-Kested also addresses the issue of the time since the rules have been last reviewed and addressed by the board. and the fact that I think, as everyone agrees, there is a consumer price adjustment in the Title V fee rule that has resulted in a significant increase in the fee rate. Importantly, Ms. Kested testimony addresses the last EPA review of the program in 2019, which did not find that the fee revenue under Title V was inadequate to support a Title V program. She describes how the fee increases would impact mining operations substantially, and how both existing fees and fees under the proposed increases greatly exceed fees paid by mining operations in other states, as well as are way out of proportion to the resources that are needed to administer the Title V program for the mining operations. An important part of the testimony is the limitation that I believe all parties agree on, which is that the Title V fee revenue can be used only to support the Title V program. Again, the NMED testimony lacks numbers about both projected fee revenue and projected expenses to run a Title V program into the future. Another witness offered by the Mining Association is Mr. Mike Sonnenberg. Mr. Sonnenberg runs air quality programs for the company worldwide and has experience as a manager of air permit programs in another state. So he can speak to you from that perspective. Mr. Sonnenberg will note that the Mining Association recognizes the needs for NMED salaries to be competitive and for adequate staffing. But again, the NMED presentation lacks information on how that translates into the need for a fee increase, and also the adequacy of existing fees, particularly for the Part 71 Title V program. Both Ms. Burke-Kested and Mr. Sonnenberg indicate that given the lack of information provided by NMED to the board to support its proposal, it would make more sense for the board not to act on the petition, but instead to allow for a stakeholder process informed by more information from NMED, such that the parties might be able to agree on some or all parts of any necessary changes to these rules. And just to conclude, the testimony from the Mining Association witnesses shows that given the accumulation of unspent fee revenue in the funds, and the fact that it will take considerable time for the board to achieve its overall staffing goals, if in fact those are approved through the legislature and such, that there is no urgency for the board to act on NMED's proposal. Thank you very much.
Let's see if this works. Mr. Hearing Officer, if possible, I'd like to reserve my opening statement till the beginning of.
Okay, that'll be fine. We're going to turn now to introduction into evidence, admission into evidence of the written testimony exhibits of the parties. I'd like to get that out of the way at the beginning if we can. So I have from the Environment Department exhibits 1 through 55, labeled exhibits NMED 1 through 55, a demonstrative exhibit that was filed, which I will mark as exhibit 50, NMED exhibit 56. And then there was an errata notice filed yesterday that wasn't marked. My copy wasn't. And I will mark that as exhibit 50, NMED exhibit 57. And then I have 2 rebuttal exhibits, NMED rebuttal 2. Mr. Prinz, does that include all the evidence, written evidence you've submitted?
That does sound correct.
Okay. Are there any objections to the NMED written testimony? Mr. Rose?
Mr. Hearing Officer, I object to the department's exhibit 15, which is a memorandum attributable to a consulting firm that says it was prepared in support of or contains the economic analysis of the proposed rule. The memo isn't attributed to anyone particular at the consulting firm, and it looks to me as if it's in the nature of testimonial. I can't question the assumptions made. No witness, as far as I can tell, offers support for the assumptions that are identified in the memo. And so we're not able to examine or cross-examine any of the content of the memorandum, in which case, from my perspective, it violates the board's rules on providing technical testimony in writing under oath to this board. And so I'll note that this consulting firm provided similar testimony or information in support of the ozone precursor rules, and the department provided someone from the consulting firm to support and be subject to examination. In this case, they have not. And so I think much of the technical support for the proposal is contained in that memorandum, and we just can't question it because there's nobody here to testify on it. So in that case, we would object to its admissibility.
Mr. Prinz?
Yes, thank you. I know that you're aware, Mr. Virtue, that the rules of evidence do not apply to this proceeding. However, if the if you do would require someone to come in to authenticate that document, the department could provide someone from that consulting firm to do so. That exhibit was referenced, I believe, in testimony. She can also speak about preparation of that and provide, secondhand. She did not prepare the document herself, but she could speak to the document and its contents. But again, also, if we can bring forward someone from that firm to authenticate the document, if you deem it necessary.
Mr. Hearing Officer, there's no question of its authenticity. The question is whether we can question the content of it, particularly the assumptions made and the conclusions reached. Without a live witness who can testify as to the preparation of the memorandum, what went into it, and the basis for the assumptions and the decisions, we're left with being unable to challenge any of the provisions of the memo. And I think that's contrary to the statute and the board's rules on technical testimony.
Mr. Hearing Officer, I would
Yes.
just like to note the Mining Association's joinder and Mr. Rose's objection, and I have another one we can address in a few minutes.
Okay. I'm going to allow the exhibit 15 to be admitted into the record with the understanding that the board can give the weight it deems appropriate to it, given the fact that the author is not identified. It hasn't been authenticated. And Mr. Prinz, if you can get someone in here to authenticate it later today, that we'll entertain that. But absent that, we'll let it in the record with the caveats I just mentioned. Mr. Mullenberg, you had an objection?
Yes, thank you, Mr. Hearing Officer. The Mining Association objects to the introduction of NMED exhibit. I believe it's intended as number 13. It's the EPA letter. That letter was only provided yesterday. It suffers from many of the same problems as Mr. Rose just described. Particularly, there's no indication of what information NMED might have supplied to EPA to support any conclusions reached in that letter. It's already been suggested by council that NMED is offering that letter as an indication of EPA's support for the rule proposal. I don't think it says that, but obviously that's their position. So for the reasons that it was not included in the pre-hearing written filings, as well as the fact that we've not found a reference in NMED's testimony to that letter, we object to the admission of that EPA letter. I believe it's dated June 20th, and I think it's intended as EPA Exhibit 13. Thank you.
Mr. Prinz?
Yes, that letter was referenced in the initial notice of intent as Exhibit 13. It had been anticipated to be received, but had not been received by the department until, I believe it was June 20th. As date, the letter, of course, it was from the EPA. It speaks for itself. The department did not obviously prepare that letter. It is a public comment, even if it's not accepted as an exhibit. It's a public comment by the EPA. I don't think the department is required to provide any, any information that it provided to the EPA, if it even did provide any information other than the petition itself, or explain why the EPA provided the letter that it did. So I'm not sure I entirely even understand the objection as it stands.
Mr. Hearing Officer, if the
Yes.
department is offering it as a public comment, I don't think we have an issue with that. Our objection is to the admission of the letter as evidence as part of the department's technical case.
Prinz, do you have any further comment?
No, I have no further.
Okay. The exhibit at issue is Exhibit 13. It was originally labeled as Exhibit 13. It was included as part of the department's technical testimony, as I understand it. But it doesn't rise to the level of technical testimony because it is simply a letter from the Environment Department from a person who's, the EPA, a person who's not available here to be cross-examined. So I am going to allow it as a public comment, but it will be excluded from the department's technical evidence. Are there any other objections to NMED's written testimony and exhibits? Okay, hearing none, I will admit the NMED exhibits I've identified, subject to the exclusion of NMED Exhibit 13 and to the caveats with respect to the weight to be given to NMED Exhibit 15. Okay, I have for the New Mexico Mining Association Exhibits 1 through 22, which is the association's direct and rebuttal testimony, 12 through 22 being rebuttal exhibits. And then I have NMMA demonstrative exhibit number 1. Mr. Mullenberg, is that summarize? Is that accurate description of the evidence of the association?
Mr. Hearing Officer, yes, that's correct. That's an accurate description of the exhibits we're offering.
Okay. Are there any objections to the exhibits from the Mining Association I just identified? Okay. The Mining Association exhibits I identified will be admitted. That gets us to the Independent Petroleum Association exhibits. I believe we only had one exhibit from them. It's a rebuttal exhibit number 1. It's a rebuttal exhibit identified as rebuttal exhibit number 1, which is testimony from Mr. Jim Winchester. We also had a written statement from Mr. Winchester that was offered. I will accept that essentially as non-technical testimony if that was the intent.
That was the intent, Mr. Hearing Officer. I attached it as a part of the notice of intent because I wasn't sure whether or not the board would consider it technical or not, but it's the same statement that he offered. It's just a public comment.
Okay. So we will I will allow, if there are no objections, the statement as a public comment. And then I will admit rebuttal exhibit 1 unless there are objections. Hearing none, the Petroleum Association exhibits are admitted. With that, we can turn to presentation of the petitioner's case. Mr. Prinz.
Thank you. At this time, I would call Michelle Miano to testify.
Testing, testing.
Yes, test this. And everyone on the WebEx virtually, can you still hear us?
Testing. I want to make sure. Hello.
Yeah.
Hello, Earth. Okay.
Okay, and may we proceed? Mr. Virtue. Oh, okay, thank you.
Please, I'm sorry. Let's swear and then proceed.
Yes.
Good morning. Could you please state your name for the record?
Michelle Miano.
Could you briefly describe your educational background?
I have a bachelor's degree from Johns Hopkins University in the writing seminars and a JD from the University of New Mexico School of Law.
Could you briefly describe your current employment?
I am the director of the Environmental Protection Division at the New Mexico Environment Department. I directly manage and support the bureaus in my division, including the Air Quality Bureau. I work with the Bureau to develop public health and environmental management policy, regulatory compliance assurance, and direct operational activities, including continuation and improvement of the NMED program. I'm also proud to be joined by many of my colleagues here in the air quality program today behind me, and there are a number of them also, if not all of them, listening online. And I particularly want to give a recognition to Rhonda Romero, who is here from the Air Quality Permitting Program, despite the fact that her house and family have been affected by the big flooding in Las Vegas today.
And did you submit your resume?
Yes, it is NMED Exhibit 3.
Did you submit written testimony?
Yes, it is NMED Exhibit 4 and NMED rebuttal testimony.
Do you have any corrections to make to your written testimony?
No.
What is the New Mexico Environment Department requesting of the EIB in this matter?
NMED is respectfully requesting the EIB to adopt its proposal to modify the regulations at Part 71, the operating permit fees, and Part 75, the construction permit fees.
Can you
Oh,
explain?
excuse me, sorry. Those are at NMED Exhibits 1 and 2.
And can you explain what is funded by these fees?
Part 71 and Part 75 in the regulations that you'll see at Exhibit 1 and 2, on the top, they say operating permit emissions fees and construction permit fees, but the term permit is somewhat of a misnomer. It is something that the regulated community sees. It's something that the public sees, but the permit is only the tip of the iceberg when it comes to the entirety of the air quality program. What is behind one permit, or what is under the water, that is the iceberg, are 4 sections, 4 teams of NMED employees developing and implementing some of the most complex regulations and solving some of the most complex problems in the environmental field to ensure that we both have a robust economy and jobs while our state air is protected. I outline each of the sections in my written testimony, and I'll summarize them now. First is our operations team. Our operations team is comprised of our air monitoring team. The air we breathe is continuously monitored by a stationary network of approximately 20 EPA designated monitors in all corners of our state that measure the quantity of certain air pollutants. These monitors provide the basis as to if our air is meeting federal health standards or not. Because our monitoring networks provide a foundation for these kinds of decisions that affect permitting and all kinds of aspects of the air quality program, we have a staff that is constantly maintaining these monitors, calibrating these monitors, providing upgrades to these monitors, purchasing new replacements, and actively out in the field day in and day out to attend to them. This data informs whether New Mexico, again, is meeting the federal standards or not, and provides direction to all aspects of our air program. Second is our planning section, or the planning team. The air quality planning team is constantly charged with evaluating and developing new regulatory plans for controlling the pollution in our air. EPA, through the federal rulemaking process, provides the direction for many of the rules that our planning team evaluates and has to integrate into our air program. They will tell you that over the past 18 months, the EPA has issued so many different new rules, it's becoming very hard for us to keep up. The planning team helps integrate the regulations and helps advise which regulations have to go into the permit. And they also house our air dispersion modelers that develop modeling scenarios to assess the applications that we receive, and also collect and analyze emissions inventories from the regulated sources. That brings us to our permitting team. Our permitting team is the team that receives the applications from the regulated entities and must evaluate those applications in light of the information from the operations team and from the planning team. These kinds of analysis are determined by the kind of permit that's submitted. determined by the amount of pollution, type of facility, and other factors. Not only is this process extremely complex, we are under statutory and regulatory deadlines to make sure that they're completed in a certain amount of time. There also, for our permitting team, if there's significant public interest on any one of these applications, our permitting team participates in permit hearings. It's a formal process, much like this one today. That brings us to our compliance team, which is a fundamental component for all of our current and future permittees. Permittees have reporting requirements that our AIR program must analyze, and inspectors that verify that the permittees are meeting their permit requirements. Our compliance team analyzes excess emissions reports, evaluates root causes of emissions events, studies permit conditions, works with companies to bring non-compliant facilities back into compliance, and helps them adhere to air quality rules.
Are there other agency operations that the Bureau relies on for its programs?
In the Air Quality Bureau itself, in addition to those teams, we also have an administrative staff that helps with all of the administrative support that each of our sections needs. That includes assisting with legal notice, document management, record management, data entry, mailing out our permits, data stewarding, and because we still receive payments by check, helps process those. We also rely on attorneys from the Office of General Counsel to advise and help us in rulemakings. And we have to rely on attorneys that are outside counsel as well. For example, the New Mexico Environment Department and our Environment Secretary are currently defendants in a civil lawsuit that, amongst other things, claims that the Air Quality Bureau is failing to regulate oil and gas pollution. Apart from the employees directly working within our air quality program that I've described, we also receive support from Administrative Services Division in our agency. That includes everything from all the HR and recruitment services to bring in qualified scientists and engineers, financial services personnel that help us with our budgeting and with our projections. And we also have procurement officers that help us contract because we're unable to right now complete all the work that we need to. We need procurement officers to help us with contracting in order to complete all of our work, and to get through the procurement system, that requires a whole nother team of specialists to make sure that we're following all the state rules that we need to in order to properly procure those goods and services. We also have IT project managers and data scientists that we depend on to ensure all of our technological operations on which we rely on more and more are functioning as smoothly as possible. This ranges from everything to our emissions inventory submission for regulated entities that went down this year, which caused havoc, to in the permitting portal for the regulated entities, to permit information housed in our Tempo database that we acquired in the 1990s.
Can you explain some of the reasons why you are requesting EIB adopt the fee proposal?
Yes, we come here to the board to respectfully request funding to allow us to fully implement as quickly as possible all that our program needs to keep the lights on, to keep what we are doing and what externally regulated entities see well oiled. Right now, we are a car that you see on the road and you think, wow, I can't believe that car is still functioning. They must have replaced the engine 5 times. They must have gotten new wheels. I haven't seen one of those in 20 years. We're not asking for a luxury vehicle. We are asking for a safe, reliable, mid-size family sedan. In order to do this, we have to upgrade and modernize each of our sections. One is our operations section. I've been working in this position for 18 months. The only thing I hear from my air monitoring team is that they desperately need more people. There are people that need to store all of their air monitoring equipment in their offices because we don't have enough space for laboratories. There are people that are responsible for air monitors all over the state that are unable to get out there, procure the new equipment that we need, and replace all the air monitors as quickly as we need to. This, if you will recall, is the data on which we base all of our decisions. For planning, we want to make sure that for the permits we issue, all the regulated entities know that your permit is compliant with all necessary regulations, properly integrated with all federal requirements, and that the regulated entities have certainty that, for example, our general construction permit fully integrates Part 50 and the new federal regulations coming down so that the regulated entities don't have to go into 55 different places. They can say, yes, the Air Quality Bureau knows what it's doing. It has the permit that has all the up-to-date regulations that provides certainty. For Exhibit 15, that is our ERG report. It shows an estimate for Title V, particularly of those decreasing revenues over time. This is not a secret. It's in all of our financial statements that are available to the public that we're audited on all the time. Those fees are decreasing. We need assistance in helping build back up the funding that is going down. We have new regulations, Quad B, Quad C. We have an entirely new pollutant that we're going to be addressing, methane. If you look at Exhibit 38, that is a satellite image from Carbon Mapper of all of the methane emission sites in the Permian Basin. We need a lot of resources to start addressing greenhouse gases, the methane regulations under the federal rules, and we need to do it as quickly as possible. And in fact, EPA is forcing us to do it as quickly as possible. We would like to make sure that in our planning section, we are being as accurate as possible with our planning models to ensure that we can identify, for example, in that Exhibit 38 with that carbon mapper, which pollution, when this is true for criteria pollutants as well, such as ozone, which we are looking at a non-attainment designation for, we're able to identify what is New Mexico's portion of that, what is the state of Texas's portion of that, and what is the country of Mexico's portion of that, because what we don't want to do is over-regulate the regulated community. We want to be able to make distinctions between what we're seeing, that's our air pollutant that we're responsible for, but we don't want to start over-regulating in our Permian Basin if we know that there are, a high percentage is from the state of Texas. We want to make sure that we know where all of those pollutants are coming from. Increased funding will allow us to do that. If we don't get increased funding, we're going to see what many of you might know is coming down the pipe, which is federal sanctions on our program. The EPA, for the Good Neighbor rule, has proposed that because we did not provide certain amount of and certain kind of information to EPA for purposes of our Good Neighbor provision, it is proposed right now in the Federal Register that it will come in and we will follow what the federal government wants us to do. This includes creating our participation in creation of an entirely new trading market for our state, which we've never had before for certain electric generating units. And so all of that work is something that we're going to have to be, we simply do not have right now the staff and ability to respond to that because we have other regulations that we're trying to work on, notably our regional haze rule. And so we likely will end up having federal sanctions on our program, which means that the federal government is telling us what to do. we are not telling ourselves what's best for New Mexico. In our permitting department, we want to promote transparency, efficiency, and accountability. We want to have the ability to have as many pre-construction meetings with existing and incoming new businesses as possible. We want to help educate non-permittees about the permitting process, which we can do in a limited way now, but which might alleviate the regulated community from a lot of opposition if there's a permit that's challenged or disputed. We want to increase our small business assistance program, which is not something a lot of folks know about. We actually have a group that its only job is to help permit small businesses and help keep those businesses into compliance. Of course, we're also going to have to address the non-attainment designation that's likely coming down from EPA. We are being told it's going to happen any day. Arguably, the GCPs that we currently use might not be able to be used anymore. And so we need to make some very important decisions in our program about, do we update the general construction permit? If so, how do we update it? Or do we go back to new source review programs, which is what the program had before the general construction permit, which of course would be another and will be a huge burden on the program. Finally, we have our compliance section. We have a 15 to 50% compliance rate. Compliance is a key function to making sure that those permits are doing what they're supposed to do. It creates a fair business environment. Nobody wants to be the permittee being the only one adhering to all of the permits while their neighbor next door is not. We need to have a culture of compliance, and we need to make sure that all of the permittees are in a level playing field so no one is getting more advantage over the other because they're not complying with their permit terms. We also need to implement Part 50, and we would like to be more responsive to compliance issues that come up and be quicker in turnaround for those so that businesses can move on and have their compliance issues resolved and focus on other matters important to their business. We want to provide one-on-one assistance for those acquiring new assets and how to come in compliance if those assets, such as oil and gas wells, are not compliant. And we want to provide one-on-one assistance as companies adopt new technology and methods for their operation to ensure that we're all on the same page in reaching those compliance goals and creating win-win for all industry. We want to make sure that we're representing and have the capacity to present the AIR program for New Mexico, our opinion to the federal government when it comes to rulemaking. Right now, we are limited in our ability for doing so. It's important to recognize that doing incorporation of all these upgrades, we understand that the regulated community does, as it should, expect smooth operations and no disruptions to its services that we are already providing to them day in and day out. Regulated entities expect that when they call us, we immediately assist. This happens. They call us, we drop everything because they have an emergency. That costs us time in some of the other actions that we have to do for other permitted activities. We're making decisions right now who to serve and who not to serve. We want to serve everyone. Our ability to meet the expectation is waning that the regulated community is used to, and this proposal will help us ensure that our services will not be compromised to them and that we can improve them to be more transparent, efficient, and accurate. Of course, all of this work requires building capacity in terms of creating new positions and teams to address those challenges, which underpins the resource needs, both in terms of internal hiring and external resources.
Are there other reasons why the department is asking EIB to accept this proposal?
Our costs of conducting business in the Air Quality Bureau have gone up because we have conducted, unlike any other agency, an evaluation of all of the salaries of our agency employees, including the Air Quality Bureau, to make sure that they are paid what they deserve and what they are required to be paid pursuant to their experience and their education. So we embarked as an agency on a very large project to correct years of mispayments to our employees, and that had resulted over time in underpayments to our employees. We have made that correction. We are paying our employees what they deserve to be paid. I mean, my team, I have to say, they deserve to be paid much, much more. But we're working towards making sure that they are paid what they deserve under the State Rules Act. We are investing in employee recruitment and hopefully retention as part of these efforts. And we are upgrading our information technology. We do not want to use a 1990 database any longer. We want dashboards, we want transparency, we want user-friendly applications, both for the regulated community so that we're on the same page as the regulated community and for the residents of New Mexico. Right now, there are 2 people in the world, or 2 people that I know of in the world, that know how to fix our database when it goes down. And let me tell you, we do not let those 2 people fly on the airplane at the same time.
Who will benefit from these changes?
New Mexicans will. Period. We're going to make upgrades. I know that one of the comments in the rebuttal testimony is that we have a balance. You'll hear that that is because of past practice. On Monday, that's July 1, that is the new fiscal year. I have a meeting on Monday to spend all of that money because of these upgrades that we need now. This is not a time to delay. I'd like to go into that meeting on Monday and make sure that I can spend as much as I can to fix these problems for the residents of New Mexico and for their health. And I also see the largest beneficiaries honestly being the businesses that we serve, because in essence, what they are buying now or paying for their permits is not serving them. We are spending too much time doing manual data entry and not providing fast service that they expect. And we really see the regulated community as a large beneficiary of these changes.
Excuse me. Can you explain the individual provision on administrative compliance costs?
Yes. What we are proposing as a department and which we implemented beginning last year, and this is based on authority from the Federal Clean Air Act and the Air Quality Control Act. We do not want the non-compliant entities, or we do not want the, compliant entities paying for the work that the Air Quality Bureau has to take on because of non-compliant entities. And this goes back to leveling the playing field. We have calculated the numbers in our proposal based on what is needed for all of the sections that I'm talking about. But you'll note what I didn't include is big, long-term, unreasonable enforcement actions. And we do not want to subject those that are making the investments in new technologies, making those business decisions to be compliant with their permit, to pay for the department's work on all of the non-compliant entities' problems and the hours and hours that we have to pour over all of the excess emissions reports, for example, or any other issues that we see. So we have, under the EIB's authority, they are able to, we want to have reasonable compliance and enforcement costs in our fees, inspections and such. which, we hope come up with no violations. But if we are working on uh, violations and the number of violations that we're seeing, this is too much of a workload. Compliant entities should not be paying for it. The non-compliant entities should.
Can you summarize your rebuttal?
Yes. The first is that we acknowledge that the calculation that the EPA uses to determine if the Title V operating permit fee is above the minimum or not, that presumptive minimum, we understand that that calculation that EPA has in its guidance is based on actual emissions. So that is a mistake that we made. One mistake that we didn't make is calculating based on our current framework of allowable emissions, which was confirmed back in the last time we went through a fee increase based on conversations with industry. The allowable emissions is what we have based our per ton rate on. So when we're proposing $81 per fee, that's based on the allowable emissions on how we calculate now. We did this because we want to be as streamlined as possible. This is what we need to run our program. And although the presumptive fee is a way you can calculate to see if your program is meeting the EPA minimum or not, with this proposal, we are exceeding that minimum anyway. And so EPA gives us broad discretion based on the unique characteristics of our programs and our needs to determine what is acceptable to run our program. And this is the proposal that you have in front of you today. I also want to address the time for that the comments that we somehow delayed this or haven't been working with industry on this. We had a public meeting that the Mining Association attended. We did not know that there was any issue with our proposal until the two parties, IPA&M and the Mining Association, filed their intent. And we met with them, and we weren't able to have a meeting of the minds, and that's okay. Nobody likes raised costs. We don't like raising costs, but the fact of the matter is costs are rising, and this is what we've calculated we need to make all of those upgrades and continue the services that the regulated entities expect. Finally, I want to address the New Mexico Mining Exhibit 9, which is also in their demonstrative exhibits, I believe. It's the Freeport chart. One of the comments made in the written testimony from Freeport is that we did not provide a rationale for the removal of total suspended particulate from air pollutant and replaced it with particulate matter. So the explanation on that is total suspended particulate used to be the term that EPA used for all those tiny pieces of matter that get embedded in your lungs and cause lung problems. That's why we regulate it. It's now called particulate matter. In error, we did not update total suspended particulate to particulate matter, which is what we're proposing in our proposal now. So the intent is that we would always have particulate matter in one way or the other as a fee pollutant. That's why we have particulate matter included in our proposal. Again, this is the small bits of matter that get embedded and lodged in your lungs, right? Think of wildfires, for example, in the recent fires down south. So we learned due to an error that Freeport has not paid this total suspended particulate or particulate matter fee pollutant charge for 7 years. Regardless of if we charge it or not, our air quality program is still monitoring for it. We're still modeling for it. We're still permitting for it, and we must do inspections and address it in our compliance team. So this is another example of an air quality program doing all the work that Freeport's describing without having received any of the fees that we're doing on that work due to an error. You'll note in Freeport's proposal, in the Mining Association's proposal, they remove our particulate matter provision where we want to charge that as a fee pollutant. As I note in my direct, the overall price of Freeport's commodity New Mexico copper, I have a citation in that report. In US dollars, over the past 20 years, it's gone from under $2,000 a metric ton to over $8,000 a metric ton. And the demand for copper, based on all the advances that we're making, is expected to double by 2030.
Is that all you have today, Ms. Bruno?
Yes.
Thank you. I have no more questions.
Forgot to turn my microphone on for persons who are attending on WebEx. We're going to take a 10-minute break. We'll come back at 11:04 and begin with cross-examination. Thank you.
Maybe we could do cross-examination as a panel, but we'll just do individual cross-examination of Ms. Piano when we return. I see. Okay. Just want to clarify.
We're going to reconvene here as soon as Ms. Piano takes her seat. We are on cross-examination now, Ms. Piano. Mr. Rose, I believe you're first.
Yeah, but Hearing Officer Virtue,
I have no particular preference if you want to go.
Hearing Officer Virtue,
Yes.
if I may, I'm sorry. But on that, it was our understanding per the pre-hearing order, and I should have indicated this from the get-go, that the department was going to present its testimony as a panel. And that according to the pre-hearing order, and our understanding of the procedure would be that if after the witnesses testify as a panel, then clarifying questions and cross-examine will occur only after all panel members have testified. That was our understanding of how the procedure would be this morning.
Okay, that's, you have the right to do that, Mr. Prinz. And my interpretation, based on the fact that Ms. Miana was the only one that came forward, was you were going to present.
And yeah, and I should have.
So if you, I don't know exactly. Yeah, we can do that. You can present your other witnesses, and then we'll have to bring them all forward and move a chair forward, and we'll have cross-examination of all of them at one time. So we will regroup, and you can proceed with your next witness.
Okay, thank you. Yes, at this time, the next witness I would call was Melinda Owens.
You please state your name and spell your name for the record, and we'll have you sworn in.
Sorry. Yeah. Yes. Excuse me.
Thank you. I know you just did, so would you please again state your name for the record?
Melinda Owens. Is that the right distance? Is it too loud?
Well, she'll let us know if it's, but please let us know if she needs to get closer to the mic. Uh, yeah, can you please briefly describe your educational background?
I have a Bachelor of Science degree in Chemical Engineering from the University of New Mexico.
And could you briefly describe your current employment?
I was hired by the New Mexico Environment Air Quality Bureau in July of 2007. I worked as a permit specialist until I was promoted to the Title V program manager in 2017. Last year, okay. Is that better? Okay. It's like an echo.
Yeah.
All right. Last year, I was promoted to the permitting section chief. During my 17 years at AQB, primary duties have included reviewing air quality permit applications, state and federal regulatory applicability determinations, and writing or reviewing permit conditions to ensure federal enforceability.
Did you submit your resume?
Yes, it is Exhibit 5. And might I note too, Michael, during my testimony, I may refer to the Air Quality Bureau as AQB or Bureau and refer to the New Mexico Environment Department as NMED or Department.
Did you submit written testimony?
Yes, my testimony is the department's Exhibit 6.
And do you have any corrections to make to your written testimony?
No.
Do you adopt the testimony in its entirety?
Yes.
What is the purpose of your testimony today?
The purpose of my testimony is to explain the permitting process in support of the proposed fee increase under 20.71 and 20.2.75 NMAC. The focus of my testimony is how the proposed fee increase will impact the administration and implementation of the minor source construction permit program.
Will you summarize the various minor source permits and registrations that are issued?
All right. A notice of intent, otherwise called NOI. NOI is a registration process for smaller facilities meeting certain regulatory criteria. In 2003, AQB processed 125 of these. 2023, we processed 633. Of those from last year, 97% were oil and gas facilities. An NOI has a 30-day issuance deadline. The current NOI fee is $500. The proposed fee is $2,000. The number of 20.2.72 NMAC NSR construction permit applications have decreased over the last 20 years. One factor is that major source oil and gas facilities, if they are under the major source category, are 100 tons per year, prefer the streamlined GCP over the NSR permit application process. Larger or more complex facilities continue to utilize the construction permit. NSR permits have a regulatory deadline of 30 days to be deemed complete or incomplete, followed by a 30-day issuance deadline. NSR fees include the review cost of $510 Per point, the current established fee was applied CPI. These points create an equitable assessment method for applicants based on permitting activities, equipment types, operation changes, review and determination of applicable state and federal regulations. Except for the CPI adjustments, there is no proposed NSR fee increase. The oil and gas general construction permit, I'll just shorten to GCP, was issued in March 2018. The 3-year development and issuance of the oil and gas GCP greatly streamlines the application, modeling, and timeline process for industry. The permit has a 30-day processing deadline. No modeling is required. GCP permits incorporate a general modeling for every GCP based on multiple factors, such as stack heights, exit velocity of emissions, and equipment location. There were 337 new and 510 revised GCP permits issued in 2023. The current GCP review and processing fee is a flat $5,100. The proposed fee is $25,500. The current 20.2.75 NMAC fee structure was promulgated in December 2003. Although the regulation allows consumer price index adjustments, the CPI increases have not been sufficient to cover the Bureau's original projections of permit actions, nor has it recognized the complexity of applications or revisions.
Will you summarize the increase of oil and gas GCP applications in recent years?
Almost 80% of all AQB air quality applications are from oil and gas. Two primary factors have contributed to the increase of permit applications in very recent years. First, oil and gas air quality permitting actions have expanded in the Permian Basin due to higher production levels. Second, the GCP issuance in March of 2018. The GCP provided oil and gas companies with an expedited and less costly application process. The combined 847 new and revised GCP permits issued last year demonstrates expanded New Mexico oil and gas activity and permitting.
How many permits on average is your the permitting division handling each week?
Well, recently we have been receiving 25 to 30 GCP permit applications each week.
And is the permitting section able to tightly process those?
No, actually, we have contracted with a company for the additional workload because our permitting staff cannot handle it. We have been assigning actually 10 GCP permit applications per week to the contractor. It is unsustainable at this point to be able to continue meeting the deadlines with the number of applications that come in.
Would you summarize the justification for an increased GCP fee?
There are multiple reasons to increase the GCP fee and increase the staffing levels, including time to review, we have seen an increase the number of regulations requiring analysis, and the application volume increase. Before I start discussing the GCP fee increase, I'd like to direct your attention to the AQB demonstrative exhibit over here. These nice people. It's a poster showing the review steps for a GCP. You can see it's quite lengthy. The GCP is preferred by industry because of the expedited timeframe and lower fees. From the Bureau's experience, the level of effort to process a GCP permit is comparable to the level of effort to process an NSR permit. Both require extensive evaluations and review, including but not limited to reviewing the process flow, emission factors, spec sheets, verifications of emission calculations, gas analyses, application of state and federal regulations. Because modeling is not required for a GCP, permit writers are required to review the stack parameters to ensure dispersion of the air pollutants. It is critical that permit writers perform a thorough and complete review of every aspect of the application review in order to ensure the health and safety of New Mexicans. In August of 2022, AQB promulgated a comprehensive ozone precursor regulation for the oil and gas industry. That's 20.2.50 NMAC. This regulation extensively addresses oil and gas industrial processes, including individual polluting units, their control devices, and the routing of those harmful emissions. Additionally, newly federally promulgated 40 CFR 60 subparts B and C are complex regulations reducing VOC and methane emissions. These regulations add responsibility and review time to the permit issuance process. In addition to the volume, time, and complexity of application reviews, the Bureau is anticipating the EPA will issue a non-attainment designation based on measured exceedances of ozone in the southeast part of New Mexico. The issuance of a non-attainment designation indicates exceedances of health-based limits for pollutants. A non-attainment designation will require New Mexico to bring that area into attainment status, further increasing the volume of work and supporting the need for additional staff and resources to support the Bureau in continuing to meet its statutory and federally delegated responsibilities. In response to the volume of applications and to ensure compliance with the statutory deadlines, as we just discussed, Michael, the Bureau has engaged contractor support to assist AQB permit writers with the workload. And indeed, on recent weeks, we have been receiving 25 to 30 GCP applications per week.
Do you have any concluding comments?
Yes. More permitting staff are required to continue permit issuances on time, accurately determine regulatory applicability, review of emissions calculations, and generally maintain the workload. As more permitting staff are added, additional support staff and other AQB sections will be required. This will include the operation and financial staff to process applications, establish and manage contracts, invoicing, and fee collection, the planning staff to support rule adoption and modeling, compliance and enforcement staff to enforce permits and process excess emission reports, and IT staff and contractors to maintain and/or update databases, create an online payment system, and assist with moving to modern applications. So in conclusion, a fee increase will enable AQB to fulfill its statutory and federally delegated responsibility to administer and implement the Clean Air Act and the Air Quality Control Act to ensure that New Mexico inhabitants have a safe place to live.
Thank you. I have no further questions for Ms. Owens.
Thank you, Ms. Owens.
Thank you.
Mr. Prinz, please call your next witness.
Thank you. At this time, I will call Eric Peters to testify.
Mr. Peters, please state and spell your name, and we will have you sworn in.
My name is Eric Peters, EricPeters. Yes,
Thank you. Good morning, Mr. Peters. Could you briefly describe your educational background?
I have Bachelor of Science degrees in Mechanical Engineering and Biology and a Master of Science in Environmental Engineering from University of Kansas.
Could you briefly describe your current employment?
I have worked at the Air Quality Bureau of the New Mexico Environment Department for over 26 years. I will refer to the Air Quality Bureau as AQB or Bureau, and I'll refer to the New Mexico Environment Department as NMED or Department. I've been the Control Strategies Manager since May 11, 2024, but I worked as an air dispersion modeler for most of my time at AQB. As a modeler, one of my primary duties was the review of air dispersion modeling for new source review permit applications to determine if they will comply with air quality standards or other modeling related requirements.
Did you submit your resume?
Yes, it's the department's Exhibit 7.
Did you submit your written testimony?
Yes, my written testimony is the department's Exhibit 8.
Do you have any corrections to make to your written testimony?
No, but I would like to make a clarification. In my discussion of mining and construction industry sources, I said, quote, "These sources are more likely to operate near communities because they produce materials that are used within the communities," unquote. Most of the mining permitting we do involves gravel mining and crushing, often with associated asphalt plants and concrete batch plants. These types of sources are likely to locate close to communities. Other types of mining that do not provide materials directly to consumers, such as copper mining or coal mining, do not have the same incentives to reduce travel distance to communities. The rest of my discussion of modeling for mining applies to all mining permitting.
Do you adopt your testimony in its entirety?
Yes.
What is the purpose of your testimony today?
The purpose of my testimony is to explain the proposed changes to air dispersion modeling fees in the fee regulation 20.2.75 New Mexico Administrative Code, construction permit fees. No distinct modeling fee is being considered for 20.2.71 NMAC, but sometimes modeling support or review is needed for Title V applications, such as some landfills that don't require construction permits and permit appeal hearings. The cost of that support would be included in the operating permit fees in general, rather than specific modeling fees for operating permits.
Will you summarize how modeling fees are charged?
Construction permit fees are calculated according to the fee regulations in 20.2.75.11 New Mexico Administrative Code. The regulation assigns points to permit applications for certain activities or characteristics to determine how complicated the analysis of the permit will be. The number of points is multiplied by a factor to determine the total cost of the permit. In this way, the cost of the permit is based on the average amount of time, of staff time and effort required to review the application. It is often difficult to predict how long a modeling review will take. Because of the unpredictable nature of modeling reviews, NMED utilizes a uniform fee method as referenced in 20.2.75.11 NMAC. This uniform fee method provides for better budget planning before and during the permit review process. The goal for recovering modeling costs is for each construction permit application to include a modeling fee based on the average modeling review effort for construction permit. When the average modeling review effort for construction permits requires changes, it is appropriate to adjust the fee to reflect the new average.
Will you summarize the changes in modeling since the fees were previously updated?
20.2.75.11 NMAC, which lists the points for permitting activities, was last changed in 2003. Since that time, various changes have taken place to modeling review and to permits. Historically, permit applications would vary in complexity. Some modeling reviews would take a relatively short amount of time, and others would take much longer to review. The fee was thought to represent the average review time of the modeling review for these permit applications. Some projects may take a few days or a week to review. Complex projects may take weeks of review time. Projects with public hearings could lead to months of a modeler's work time to prepare for hearings and appeals. Over the years, we have developed various general construction permits, or GCPs. These are permits that simple or moderately complex facilities can register for. Applications to register for GCPs do not require modeling because the Bureau spent considerable time modeling all the scenarios covered under the GCPs in advance of issuing the permit. Permit applicants can register for existing general construction permit instead of being issued a regular permit. No new permit is issued when someone registers for a GCP. The average modeling complexity has increased greatly because the simple and moderately complex facilities normally register for GCPs instead of applying for regular permits that require modeling to be submitted with the application. Normally, only the most complex facilities now submit modeling, so the average review time is much greater than it was last time the permit fees were updated in 2003. I would like to draw your attention to NMED Exhibit 49, AQB count of GCP and NSR permits issued by year. This is a graph that compares the number of registrations for GCPs with the number of regular permits issued. The GCP count includes all types of GCPs, not just the various oil and gas GCPs that have been used over the years, and all types of regular permits, including PSC permits. For years, there were frequently more new source review permits or regular permits than GCP registrations. In recent years, the regular permits have been decreasing and GCP registrations have increased greatly. This data supports my experience that GCPs have successfully eliminated the need for most permits to do modeling, so only the most complex facilities that take the most review time now need to submit modeling. The result is that the average modeling review time is now much greater than it was in 2003. The simple facilities that only take a few days of modelers' work to review now get GCPs instead of regular permits. Since the easy facilities no longer have modeling requirements or modeling fees, the average time per modeling project increases. The construction permit modeling for complex facilities remain, but for easy projects, that essentially gave the complex facilities a discount by reducing the average work time per project have been removed by the success of the GCP implementation. Changes to regulations, guidance, and air quality standards have also made modeling more time consuming since the last fee updates. The addition to time directly spent reviewing modeling, in addition to time directly spent reviewing modeling staff spend considerable time maintaining the infrastructure required for modeling review. Modeling staff update the New Mexico modeling guidelines, review new regulations, review modeling protocols and waiver requests, provide background concentration or background information used in modeling, and develop software to provide or analyze modeling content.
Would you describe the proposed modeling fee change?
It is often difficult to predict how long modeling will take. I'm sorry. When a permit application requires an air dispersion modeling analysis, the schedule currently assigns 15 points to that application. The proposed fee regulation will account for the increased average complexity of modeling analyses by doubling the modeling points to 30 points. The proposed fee is more reflective of the staff time required for an average modeling project in the current environment.
And would you describe how modeling relates to the proposed GCP fee change?
Extensive modeling work is required to develop and revise general construction permits. This work is required to simulate the effects of nearly endless possibilities of equipment on the environment and translate the results into effective permit conditions. The cost of a GCP creation and maintenance is not reflected in the current fees for GCPs themselves, as no modeling is required for each GCP application and no modeling fee is charged. Some of the proposed increases to GCP fees may be used to absorb these expenses.
Do you have any concluding comments?
Large increases to the average review time for air dispersion modeling require similar changes to the modeling fee structure if the department is to recover these labor and related costs through the permitting process that the modeling is required for.
Thank you. I have no further questions for Mr. Peters.
Okay, thank you, Mr. Peters. Mr. Brind, you may call your.
Thank you. I'll call up Ms. Donna Intermont at this time.
Please state your name and spell your name, and then we'll have you sworn.
Good morning. My name is Donna Intermont, and that spells D-O-N-N-A. Intermont is I-N-T-E-R-M-O-N-T. Intermont, not Termount. I do, yes.
Good morning, Ms. Intermont. Could you briefly describe your educational background?
I have a Bachelor of Science degree in Medical Technology from the University of New Mexico and a Master's of Business Administration from Southern New Hampshire University.
Could you briefly describe your current employment?
I have worked for the Air Quality Bureau of the New Mexico Environment Department for 14 years. I will refer to the Air Quality Bureau as AQB or Bureau. I will refer to the New Mexico Environment Department as NMED or Department. I worked as the minor source permit manager from November 2011 to June 2012 at AQB, but I have worked as the operations section chief since June 9th, 2012. And as the operations section chief, one of my primary duties is to manage the Bureau's operations and finances.
Did you submit your resume?
Yes, it is the department's Exhibit 9.
Did you submit your written testimony?
Yes, my written testimony is the department's Exhibit 10.
Do you have any corrections to make to your written testimony?
No.
You adopt the testimony in its entirety.
Yes.
What is the purpose of your testimony?
The purpose of my testimony is to explain the Bureau's budgets and funding sources that support the construction permit and Title V operating programs.
Will you just summarize the financing of the Air Quality Bureau?
Yes. The fiscal data in my testimony was derived from reports and information collected by the department's Administrative Services Division, Budgets Bureau, and fiscal staff working in the Air Quality Bureau. Each budget in the AQB has 3 categories of authorized expenditures. First, personnel salaries and employee benefits, known as the 200 category. Second, the contractual services, known as the 300 category. And third, other. This is rent, supplies, travel, court reporters, public notices, utilities, etc. And this is known as the 400 category. Personnel salaries and employee benefits constitute 75 to 80% of total expenditures. The Air Quality Bureau has 4 recurring funding sources. First, the construction permit fees, known as SRF 63100, also known as the New Source Review or NSR fees. Secondly, the Title V operating permit fees. This is known as SRF 09200, also known as the Title V or TV Title V fees. Third, the EPA Clean Air Act 105 Federal Grant Fund, also known as the 105 grant. EPA Clean Air Act, this is the 4th fund, recurring funding source. EPA Clean Air Act 103 Federal Grant Fund, also known as the 103 grant. Statutes, regulations, and grant funds dictate how these funds may be expended. All funding sources, except for the 103 grant, are subject to an indirect cost assessment to pay for administrative services provided by the department, currently at a rate of 35.2%. This is NMED Exhibit 50. In addition, the 105 grant must be matched with state dollars, 60% federal and 40% state. The construction permit fee fund is used to meet the 40% match requirement for the 105 grant and is used for fiscal year expenditures. The 103 grant is 100% federal and is provided for EPA special projects only.
Does the Air Quality Bureau receive general funds?
Yes, the AQB generally does not receive recurring general funds to support its programs, but in recent years, the AQB received general funds in the amount of $109,000 for fiscal years 2023 and 2024.
And has the Bureau's annual operating budget increased?
Yes. AQB's annual operating budget from fiscal year 15 to fiscal year 23 increased from 9.3 million to 13.6 million. This increase is due to salaries and benefits, technological and service contracts, rent, telecommunications, and equipment. A large part of this increase for fiscal year 24 was due to a 3.5 million appropriate placement salary project, which Michelle Miano referred to. This included salary increases for most all employees dependent on their pay band, education, and experience. The cost of employee benefits has increased as well and is currently based at a rate of 40%.
Would you discuss the construction permit fees?
NMED Exhibit 51 displays the construction permit fees collected since fiscal year 2012. The EIB revised the fee schedule in March 2001. Each year, AQB utilizes the change in the Consumer Price Index to calculate the construction permit annual fees. The annual revenues increased marginally between fiscal year 12 and fiscal year 18, but not enough to cover the full cost of the construction permit program and future growth needs. Reviewing NMED Exhibit 52, the construction permit fee budget fully funds 36 AQB positions, including the Bureau's rent, telecommunications, travel equipment, and many other expenses. The 105 grant was mentioned earlier as one of the 4 funds financing the Bureau. The 105 grant is the primary mechanism for EPA involvement in air quality issues in New Mexico. Section 105 of the Federal Clean Air Act authorizes the EPA to make these grants to states for implementation of air pollution control programs. But EPA awards from the 105 grant only support 22% of the overall needs of the program. In addition, EPA awards the 105 grant each year pursuant to a negotiated set of grant commitments. Some of these grant commitments involve the construction permit program. As stated earlier, one of these grant commitments requires AQB to match the 105 grant dollar for dollar. The match requirement must be at least 40% state funds to 60% federal funds. The construction permit fee fund is used to meet this 40% required match. This commitment rises each year under the principle of maintenance of effort. For the 105 grant, this principle means that the AQB must increase the percentage of state match each year. As stated in my testimony, the Environmental Improvement Board is required to adopt a fee schedule sufficient to pay the reasonable cost of operating a construction permit program. The fee schedule cannot satisfy this requirement by using past administrative practice of conserving funds and limiting expenditures. Additionally, the exclusive use of the Consumer Price Index to calculate annual fee rates provides only a minimal increase in revenue and cannot sustain the Bureau for future staffing needs. Modernized processes, increased number of contracts, demands of improved technology, and increased number of public hearings and appeals. All of these items have greatly impacted the Bureau's funds.
And would you describe the Title V operating fees?
The New Mexico Title V program was adopted by the EIB in 1993, approved by the EPA in 1994, and the Bureau has been collecting Title V fees since 1994. The fees are identified as Title V revenues and are used to pay the expenses of the Title V program. Between January and April of each year, the Bureau's technical staff verifies that the data system accurately reflects the allowable emissions for Title V sources within our jurisdiction. These data are derived from each source's most recently issued Title V or new source review permit effective on December 31st of the previous year. Based on these allowable emissions, no later than April 1st, the Bureau generates and mails an invoice to the owners of each source. The invoices must be paid no later than June 1st. During June of each year, the Bureau prepares a Title V budget for the following fiscal year based on the revenues expected from the newly issued invoices, including the balance in the fund. It is critical that the Bureau be able to demonstrate that planned recurring expenditures from the fund can be supported by the projected revenues and fund balance. After the budget is adjusted to obtain Department of Finance and Administration and Legislative Finance Committee approval, it is incorporated into a spending bill that is passed by the legislature and signed by the governor. This budget becomes effective on July 1 of that year. If the Bureau were not able to use allowable emissions, the Bureau would not be able to plan recurring expenditures and budget effectively for the Title V operating program. However, in recent years, Title V revenues have declined. Title V revenues from 2012 to 2023 are shown on a data chart titled Final Financial Analysis, NMED Exhibit 51. Initially, the data shows the relative stability of Title V revenues. As older sources are taken offline and newer sources are constructed or modified, the billable emissions have remained stable and without significant variation. Using allowable emissions as the basis for billing has little effect on revenues from year to year. Over a longer period, however, the situation is different. The data shows the gradual decline of revenues in recent years. Two major factors contribute to this decline. First, several facilities have reduced allowable emissions through modifications or pollution controls, in some cases to resolve enforcement actions. Some of these facilities have reduced allowable emissions so significantly that they became synthetic minor sources and no longer pay Title V fees at all. Some facilities have avoided Title V fees through the source shutdown provision and paying a reduced fee. In particular, the recent shutdown of the San Juan generating station in the northwestern part of the state on November 1st, 2022, has reduced Title V revenues substantially by approximately $556,055 per year.
Would you describe EPA's established presumptive minimum fee and its relation to the Title V program?
In 1989, EPA established an original presumptive minimum fee of $25 per ton. Please see it NMED Exhibit 53. EPA assumes that a state air agency is sufficiently funded to carry out the functions of a Title V program if the state assesses at least the presumptive minimum fee. EPA updates the presumptive minimum fee amount annually, and the current presumptive minimum Title V fee, effective September 1st, 2023 through August 31st, 2024, is $61.73. New Mexico's current Title V fee of $38.47 per ton is less than EPA's current presumptive minimum of $61.73 per ton. And it is appropriate that the fee be increased to fully support the Title V operating program and future growth needs.
Do you have any concluding comments?
Yes. The consequences of not increasing the fees are serious. If the EIB delays its decision or rejects all of the fee schedule options, there would be an immediate adverse effect on the construction permit program. The Bureau would not be able to fully fund AQB programs. The AQB cannot count on other revenue sources. The AQB cannot reliably predict the amount of monies that the legislature would appropriate from the general fund, the amount of future 105 grants, nor the portion of those grants allocated to the construction permit program. EIB's approval of the proposed fee schedule will ensure that the AQB is able to satisfy its statutory obligation and federally delegated responsibilities.
Thank you. I have no further questions for Ms. Intremont.
Okay, does that conclude?
Yes, now we'll
testimony?
conclude
Okay.
all testimony from.
Okay, it is 11:57. It's lunchtime. break for lunch and come back at 1 o'clock. And we'll start with public non-technical testimony. If there is any, as of now, we don't have anyone signed up. We'll do that first. If folks are available and want to testify, then we'll go to cross-examination of the NMED witnesses as a panel. Regarding the question that came up about order of cross-examination, paragraph 10 of the first pre-hearing order said the order would be the reverse of presentation of witnesses. Having said that, there's no magic to that in particular. So if council prefers to go in the order, the order that witnesses were presented, that is acceptable. So I'll allow it up to council in terms of what order to proceed in. So if there is nothing further, we'll recess until 1 p.m. And we are now on the record. We have, no person has signed up on the sign-up sheet in the room, and no person has notified the WebEx host if they want to make public comment. Is there anyone in the room here today, right now, that wants to make a public comment or testimony? Okay, and is there anyone on the WebEx feed that wants to testify? If so, send a chat message to the host. Okay, having received no request for public comment, we'll proceed with cross-examination of the Environment Department witnesses as a panel. Mr. Prinz, if you'll have your witnesses come be seated at the witness table. There are two handheld microphones on the witness table desk that can be passed back and forth to the witnesses who are sitting by the side of the desk.
About that, yeah. No, sorry. I was just for my own clarification, I was looking at the pre-hearing order though too, and I guess I thought that everyone was going, all parties were going to present their testimony, and then cross-examine would come after that in the reverse order of their direct testimony. So the intent was of the order was that each party had the right to present its witnesses as a panel, and if that is the case, they would be cross-examined at the end of their case, the end of each respective case as a panel. So, and then I just adjusted the order to allow the order of presentation of witnesses the order of presentation of witnesses will be the order of cross, which would mean the Mining Association would go first, and the Independent Petroleum Association would go second. So that's where we are. Okay, because the hearing order said thereafter cross-examination by the parties will be in reverse order of their direct testimony. So yeah, that's the piece I changed. I revised. I just requested that we stick to that hearing order, but yeah, unless there's some reason to not stick to the hearing order. Well, there's a request to council to switch the order of cross-examination, and in my view, there's no prejudice to doing so. It's basically just switching in terms of which
lawyers go first to cross-examine.
Okay, you say that there was a request from,
Yes, that was prior to the lunch break. There was a brief discussion about the order of cross. And I had pointed out that the pre-hearing order does say the reverse order of witnesses. Counsel had indicated they would prefer just to go in the order of witnesses. That is to say, the lawyers would cross-examine in the order their witnesses testified.
okay, because I don't recall any.
So since you, let me clarify, since your witnesses go first, you won't be cross-examining them. So the next witnesses to appear are the Mining Association, and after that, the Independent Petroleum Association. So they will cross-examine your witnesses in that order.
Okay.
So we're on the cross-examination of your witnesses as a panel.
As a panel, okay.
So
That's my own confusion. So. Oh, you can vote, sure. Yeah.
Okay, are the witnesses ready?
Yes.
Okay. Thank you. We'll proceed with cross-examination. I'd ask counsel to direct their questions to one specific witness unless you have a specific reason to throw it out to the group. And then if the witness to whom a question is answered doesn't feel like they can answer it, or one of your cohorts can answer it better, you can defer to one of your cohorts to answer the question. Mr. Mullenberg.
Thank you, Mr. Hearing Officer. Good afternoon, everyone. We appreciate your testimony and have a few questions to follow up on your written testimony and summaries. Let me start by directing a question to Ms. Miano, and the first part of it actually is a point that I believe we agree on, and that is that fees collected for the Title V program under Part 71 of the EIB rules can be used only for purposes of the Title V permit program. Is that correct?
Yes.
Ms. Miano, the department provided some information relating to the Air Quality Bureau staffing for fiscal year 2025. And is it correct that your testimony indicates that NMED is seeking to increase the overall Bureau staffing from a current level of 94 to a total of 110?
I'm sorry, is there a document you can point me to? Sorry.
Yeah, I took the 110 number from the fiscal year 2025 strategic plan, I believe it is. You have the exhibit number by chance, Sam? That would be exhibit 35.
Okay, I'm at exhibit 35.
Pardon me?
Is there a page that you'd like to?
Yes. I'm looking at page 14 of exhibit 35.
Got it. Yes, it says 110 FTE, budget 17 million.
Ms. Biano, specific to the Title V program, NMED's testimony does not contain an estimate of the anticipated expenditures for that program for 2025 fiscal year, does it?
I can tell you that our anticipated expenditures for 2025.
Excuse me, Mr. Herringhoff, sorry, I didn't ask what the anticipated expenditures are. I'd ask if they're in the testimony.
This is our budget.
If you could just respond to that, what was asked, Ms. Miana?
This says our budget is 17 million.
But Ms. Miano, that's the total Air Quality Bureau budget, right? Not just the budget for the Title V program.
Yes.
Thank you. And Ms. Biano, the department's testimony does not contain an estimate of the anticipated revenue that would be generated from the Title V fees under Part 71 if the board adopts the department's proposed changes. Is that correct?
I think the math is quite easy on that. Yes, it does. It's $81 per ton times the allowable emissions. So we're anticipating it being a little over $8 million under our fee proposal that will raise for Title V.
Yeah, Ms. Miano, again, if you could listen to the questions, because I asked about the fee revenue and I asked if that was in your testimony. I'm not asking you to supplement your testimony with new information. I'm asking you about what you've already provided in the record.
My testimony says that we're going to be raising $30 million. And then if you calculate from what that derives from both of the funds, 8 million is from the Title V fund and the remainder is from the NSR fund.
But those numbers are new numbers that you're presenting newly now. Those are not in your testimony, right?
They're in my testimony.
The $8 million number is in your testimony?
The $30 million in my testimony.
Right.
With
Only
doubling the
30.
program.
Yeah, only the 30.
With doubling the program.
Ms. Miano, in your summary today, you mentioned the issue of accountability. Isn't it true that the department is proposing to remove a provision from the current Part 75 rule that requires the department to provide an annual review relating to fees collected and expenses to the board each year?
Yes, because that information is already public.
Ms. Miano, you talked a little bit about the costs of copper in terms of the commodity price. The fees under Parts 71 and Part 75 are not based on commodity prices, correct?
Correct. They're based on what our air quality program needs to run its program successfully.
And your testimony related only to commodity prices and did not address increases in production costs over 20 years. Is that right?
That's right. We haven't been provided those numbers.
Ms. Miano, there was some testimony you provided concerning the EPA presumptive fee rate of around $67 a ton for actual emissions, right?
Right.
But the proposal with regard to Part 71, and I think you've said this, is to increase the per ton rate to $81 per ton, right?
Yes.
So even not accounting for the difference between the per ton rate for actual emissions versus the per ton rate for allowable emissions, the $81 per ton is higher than the EPA $67 per ton rate, correct?
I would disagree with that because the $67 per ton rate, as we've identified in our testimony, is based on actuals. And so that is not applicable. That's no longer applicable because our per ton fee is on allowables that we've been collecting over time. And so I think the point there is, regardless, we are above the minimum that EPA is requiring for us to have a minimum level of program funding.
Ms. Miano, NMED's direct and rebuttal written testimony did not disclose to the board the unspent balances in the two funds where fee revenues are collected. Is that correct?
I don't recall, but I don't believe so. That was provided by the Mining Association.
Fair enough. Okay. That's all I have for Ms. Miano. Ms. Catalano has some questions for some of the other witnesses.
You may proceed.
I'm sorry about that. I have some questions for Ms. Owens. Good afternoon, Ms. Owens. Ms. Owens, do you have access to NMED's Exhibit 51?
Thank you. Give me just a moment if you would. Thank you. I have.
Okay, thank you.
Okay.
I have a larger version if that would be helpful.
Actually, I have a small version of that in my little book here. So depending on what you're looking at, I can help you with it because it's more readable.
Like a bigger version?
Sure. Might I preface this with, this is not my spreadsheet. It comes from operations. And so I may not be exactly knowledgeable on how everything was run. So, okay.
Thank you for that, Ms. Owens. Yes, ma'am. Is that better? Ms. Owens, in your direct testimony, I believe that you stated that the purpose of your testimony is to explain the permitting process in support of the proposed fee increase under 20.2.71 NMAC and 20.2.75 NMAC. Is that a correct summary of your statement?
That is, and I continued on with the testimony specifying that I was focusing primarily on the minor source permit section.
Yes, thank you. And in reviewing your testimony, Ms. Owens, you seem to discuss mostly the NSR permits and the GCP oil and gas permits. I'm sorry, you unable to hear me?
I'm sorry, would you repeat that?
Yes, ma'am. Ms. Owens, in your testimony, you discussed the NSR permits and the GCP oil and gas permits, but I noticed that you did not discuss the Title V permits. Is that correct?
I did not address the Title V permit fees, correct?
Title 5, excuse me. Thank you.
Yeah, the Title V. Yeah, it was primarily a focus on the minor source permits and registrations.
Thank you. And Ms. Owens, on page 3 of your direct testimony, which we have as an NMED Exhibit 6, you note that the number of new and revised NSR permits have decreased slightly over the past 20 years, primarily due to oil and gas companies opting for the expedited and less costly GCP permits. Is that an accurate summary of your testimony?
Yes, it is. I have it in front of me, and I ran our database figures, and that is correct.
Thank you. And Ms. Owens, now looking at NMED's Exhibit 51, there's a column about the middle of the large document that I gave you, which is NMED Exhibit 51, that says NSR GCP fee records. Do you see that column?
I do.
My understanding of that column is that it relates to the number of facilities with NSR GCP fee records. Is that accurate?
I might imagine that, but I did not create this Excel spreadsheet. That was operations, and so Ms. Intermont can address that. And so I defer to her.
Thank you, Ms. Owens.
Yes, I'm Donna Intermont, and that reflects the number of GC permits.
Thank you, Ms. Intermont. And when I'm looking at that column, Ms. Owens or Ms. Intermont, I am noting that the number of permits has increased since 2012 to 2023, which is the last data point we have here. Is that correct?
Yes.
And that has also increased the revenue, which is shown in the column to the right, by my understanding of this table. Is that correct?
Correct.
Each NSR GCP that is filed contains an application filing fee under 20.21.75.10A. Is that correct?
Yes.
So, Ms. Owens, as the number of GCP applications increases, the fees collected by AQB for that fee are increasing as well. Is that correct?
Yes. Yeah, the GCP, oil and gas GCP, was not issued until 2018. So this also includes a variety of other GCPs, I suppose, but since I didn't create the spreadsheet, I don't know. There were other types of oil and gas GCPs as well as construction industry GCPs. So I don't really know to what extent this includes what.
Thank you, Ms. Owens. That concludes the questions I have for Ms. Owens. I do have some questions for Ms. Intermont as well. May I proceed with those?
Proceed.
Thank you. Good afternoon, Ms. Intermont. Do you have exhibits in front of you? NMMA Exhibit 8, also NMED Exhibit 51, and NMMA Exhibit 20. If you don't, I can get them for you.
This is Eric Peters exhibit.
Could you repeat those numbers again, please?
Yes, ma'am. NMMA Exhibit 8, NMMA Exhibit 20, and NMED Exhibit 51. I have copies I can provide for you.
Oh, that's fine. Thank you. Okay, I have number 8 MM. See, yes, NMA NMMA Exhibit 8.
Okay.
And then 51, NMED Exhibit 51. NMMA Exhibit 20.
Perfect.
Correct?
Thank you very much.
Okay.
And Ms. Intermont, are you familiar with this NMED Exhibit 51?
51, yes.
And I know that Mr. Mullenberg already asked Ms. Miano this question, but Ms. Intermont, would you agree that fees collected under Part 71 for the Title V program fees can only be used for Title V permit program costs?
That's correct.
And Ms. Intermont, I was just a bit confused when I was reviewing your testimony and NMED Exhibit 10 at 3. You refer to the funding of the construction permit program from 3 sources: the construction permit fees, the EPA Section 105 grant, and the Title V annual emission fees.
No, my testimony was stating which funds actually support the Bureau. And that would be the Construction Permit Fund, also known as NSR, the Title V Operations Permit Fund, Title V, the 105 grant, EPA 105 grant, and the 103 grant from EPA.
Okay, so to clarify, your testimony is that those sources are to fund the Bureau, not specifically the construction permit program.
Right.
Okay.
The point I was making in my testimony is how the construction permit program fund is paying a 40% match to the 105 grant.
Thank you.
Sure.
Ms. Intermont, in your testimony, you note that historically, construction permit fees are insufficient to cover the cost of the construction permit fee program. Is that summary of your testimony accurate?
Repeat that.
Yes, ma'am. In your testimony, you note that historically, construction permit fees are insufficient to cover the cost of the construction permit fee program. Is that an accurate summary of your testimony?
Correct.
Is your testimony based on the information in NMED's Exhibit 51?
Yes.
I'd like to ask you some questions now about NMED's Exhibit 51. First, I want to clarify whether the information in this document is fiscal year format or calendar year.
It is calendar year, as you see in the far left corner.
Okay, so in your testimony, I believe you refer to it as fiscal year.
Yeah, that's true. Our tempo system can only, it works on calendar year. So that's how we pull our data.
Thank you. I'm going to go ahead and go through the columns of this table, except for the 2 GCP columns that we've already clarified, so that you can help me understand what each of these columns means. Starting with the second column from the left, the NSR annual fee records. Does this column provide the number of NSR facilities permitted by year?
This is the number of permits, NSR permits.
And the next column is the revenue generated by that permit?
Correct.
And the next column that says TV/EE annual fee records. Is this the number of Title V permitted facilities by year?
Correct.
And the next column is that the revenue generated by those facilities?
Correct.
And the next column to the right titled NSR permit review fee records.
Correct.
Per action, is this the number of fees generated under a review action?
Yes, under what we term a general review fee.
And the column to the right of that is that revenue generated for those general review fees?
Correct.
The next column that is titled subtitle revenue. Is this revenue only Part 75 construction permit program revenue, or does this include Title V revenue?
This is NSR and Title V and general review.
Thank you. The next column to the right that's titled NSR NOI records. Is this the number of NSR facilities that have filed a notice of intent in a given year?
This is the number of NOI permits, if you can call it a permit.
And the column to the right of that is the revenue based on the NOI permits?
Correct.
We've already gone over the GCP fee records and revenue. I'll skip those. To the right of the NSR GCP revenue, there's a white column on my spreadsheet that says total revenue tempo.
Right.
Does this column only include construction permit fees under Part 75, or does this include Title V revenue?
This includes NSR, Title V, general review, and the NOIs. Oh, and GCPs.
Thank you. The next column to the right, which is titled NSR revenue share, followed by SRF 63100. My understanding is that this column contains the revenue from construction permit fees under Part 75. Is that correct?
Under Part 71, 63,100, and 0920 is the Title V.
I'm sorry.
Yeah.
I misspoke.
And so let me speak to the share system.
Yes, ma'am.
Is that okay? So the share system is a separate system from Tempo. Okay. So the share system is the actual state's financial system.
Okay. So to confirm, the share 63100 are the construction permit fee revenue.
Correct.
And the next one over, the 09200, that revenue is from the Title V fees.
Correct.
Okay. The next column over is the combined revenue from those two Part 75 and Part 71 fees, correct?
Correct.
And then the expenditures for each, and the next two give the expenses for first the construction permit fee program and then the Title V permit fee program.
Correct.
And then the next column that says total expenditures, is that for all of the total of both programs?
Yeah. Those are total expenditures for both.
And the final column on the right titled AQB operating budget, is that the annual operating budget of the Bureau?
Correct.
Thank you for going through that with me, Centermont. In your testimony at page 3, you note that Exhibit 51 displays the construction permit fees collected since calendar year 2012, and that the annual revenues increased marginally between 2012 and 2018, but not enough to cover the full cost of the construction permit program. Is that summary of your testimony accurate?
Yes.
Looking at NMED Exhibit 51, revenue from construction permit fees in 2012 was approximately 2.3 million, and expenses of the fund was approximately 2.2 million. Is that correct?
From the share system, yes.
Can you explain what you mean by that?
Well, my statement just now, you mean?
Yes, ma'am.
Well, what I'm trying to say is I just want to make it clear that this is from our financial system. But yes, total expenditures for our NSR are 2.2 million, roughly. NSR revenue 2.3.
Ms. Endermont, is there a reason to believe that the information from your financial systems are not correct?
No.
If you look at an NMED Exhibit 51 for calendar year 2018, revenue from the construction permit fees was approximately 4.5 million, with expenses at approximately 1.8 million. Is that correct?
You want to, could you repeat that, please?
Yes, ma'am. And from this table, in 2018, revenue from construction permit fees was approximately 4.5 million, and expenses were approximately 1.8 million. Is that correct?
That is correct.
Based on these figures for 2012 and 2018, do you still agree that the construction permit fees from 2012 and 2018 were insufficient to cover the expenses of that program?
I can state this, that we had our fees swept at one time. I believe it was the year 2017. Can't confirm that exactly right now, but it was 17 that dramatically affected our revenue for both NSR and Title V. As you look further down in 2021, we were able to receive, I think it was 21. I'm sorry, do I have that right? 20, right? Yes, in 21, we were actually given back the 3 million that was swept from our Title V fund. We were not given back what we were, what was swept from our 63-100 fund. So in turn, what that did for us for that period of time from 2017, 18, you know, at that point, then we had to conserve funding as we always had been. And we had to limit our expenses. So this is a good example, that particular year, of what we were going through at that time.
If we look at the table now for the Part 75 construction permit program for calendar year, 2021, it looks like revenue was approximately 6.2 million in 2021. Is that correct?
For NSR, yes. And can I also say, this includes the residual. It's not that year's revenue. It's revenue from the previous year plus new revenue.
So is your testimony that the numbers in this column are based off of monies from the fund from the previous year?
Correct.
Okay, if you look at the expenses for 2021 under the construction permit program, those look to be approximately 5.8 million in 2021. Is that correct?
Could you repeat that, please?
Yes, looking to the expenses for, it's labeled as share SRF 63100 in 2021. I'm showing that to be 5.8 million approximately. Is that correct?
Correct.
Would you agree then that for the construction permit program in calendar year 2021, revenue exceeded expenses?
Just barely.
Thank you. And if you look at the revenue and expenses for calendar years 2022 and 2023 under the Part 75 construction permit fee program, would you also say that revenue exceeded expenses for those years as well?
Yes.
If you look now at the revenue and expenses for the Title V permit programs for years 2021, 2022, and 2023, would you agree that revenue exceeded expenses for that program over the last 3 years as well?
Yes.
Ms. Endermont, on page 10 of your direct testimony, which was filed as NMED Exhibit 10, you state that the consequences of the board delaying its decision or rejecting AQB's proposed fee increase are serious and include, quote, an immediate adverse effect on the construction permit program. Is that an accurate summary of your testimony?
For the needs of the Bureau and the growth needs of the Bureau, it is a serious decision. And so if we were unable to grow, our technology system is so far behind. We have a very archaic financial system. We have a very archaic manner of doing our fee collection every year. We have a outdated tempo system that has been sunsetted. So we have no way of maintaining that system right now other than using our IT group. So that needs to change. We're struggling now because of this. Plus, we also, of course, as we've mentioned, our staffing is extremely low. People are working double and triple amounts of permit loads. So something needs to change. So,
Ms. Endermont, have you reviewed NMMA's exhibit number 20, which is the Sunshine Portal Fund Balance Sheet, which I gave you a copy of? I think it's sitting right in front of you over left.
oh, this one. I think it's this one. Yeah. I haven't reviewed it, but
If you look at the top of the second page, the first line has a code 6310. It says Air Quality Permit Fund.
Right.
And it says 19,224,456.
Right. That's the total balance of the NSR and Title V. All residual balance.
Okay. And if you look about 6 lines down, Ms. Endermont, there's a code 0920 Air Quality Title V with a fund balance of $6,067,022.50. Do you see that as well?
Yes.
The unspent balances for these two funds combined is over 25 million. Is that correct?
Yes.
wouldn't you agree that the unspent balances from these two funds would be available to supplement any shortfall in fees that were collected in the next fiscal year versus the program expenditures?
Okay, I'm going to divert this question to Michelle Miano.
Thanks, Donna. I just wanted to note that this is a snapshot of the past and that policies change, administrations change. Our directive is set forth in our strategic plans has been to spend the money that we have and upgrade the systems that we need as soon as possible. So we already have our FY25 budget that we have presented as over $17 million. If we don't receive revenue from this fee increase proposal with our strategic plan and our new vision, we will immediately be in the black in the red instead of the black for the next fiscal year. And so although a snapshot of the past, numbers in the past were dictated by policy. And our policy now, as set forth in our strategic plan and our needs of the program, sets forth a different future.
Thank you, Ms. Miano. I have no further questions for these witnesses.
Mr. Bircher, I have just a couple of more questions. Ms. Intermont, I appreciate you raising the topic of funds being swept from these funds by the legislature. Do you recall your discussion of that?
Yes.
Just to get an understanding of what that means, is it correct to say that the legislature has the authority to remove or sweep funds, fund balances from these funds if it chooses to do so?
What I've experienced, yes.
Okay. So if there are accumulated balances of unspent funds, there's a risk of the legislature sweeping them and using it for other purposes, right?
I'm going to divert that to Michelle.
Okay.
I'll note that when our funds was swept, one of the reasons why we were able to bring it back is because of the point that we have been discussing today, which is that Title V operating fees can only be used for Title V operating purposes. So although the legislature from time to time tries to sweep funds, we, in that case, our secretary was able to recover them because the legislature did not have the authority to do that. And in fact, we've been directed by the legislature to not request general funds for our programs that can be supported by fees, like the air quality program, because
Mr. Hearing Officer, this answer again is going beyond the question. I think the first part was fine, but now we're having an explanation that goes quite beyond the scope of the question.
I believe the witness is just explaining the ramifications and how the sweeping system works. So you can proceed with your testimony.
so for the legislature sweeping, the legislature from time to time directs our agency to do things. And one of the directions from the Senate Finance Committee has been to raise our fees to support our program in the way that the legislature intended, which is for the board to ensure that the air quality program has the fees that it needs instead from the permittees, instead of going to places like the general fund, which is funded by, the individual taxpayers. So just wanted to make that clarification.
Thank you, Ms. Miano, for that clarification. But of course, as I think we've all agreed, as it relates to the Title V fund, that's limited by the appropriate expenditures that the department can make for purposes of the Title V program, right?
The Air Quality Control Act requires the board to ensure that for Title V and for construction permits that we have the ability to fund all of the programs with reasonable fees.
Could you point to the language of the Air Quality Control Act that you're referring to?
74-2-7B.
And if I recall correctly, that provision says that the board has authority to set a schedule of fees consistent with the Federal Clean Air Act provision that relates to the Title V program and the limitations on the uses of fees collected under that program or the Title V program, correct?
I think it just references in accordance with the federal program.
Right. You mentioned the word reasonable, but I don't think we would disagree that it's up to the board to consider the reasonableness of fee increases when it's looking at changes to its rules, right?
I would say that for the Title V guidance particularly, EPA is very deferential as to what state air programs need. And so there's quite a few pages of guidance, I think that, the Mining Association provided in the record here that speaks to that. It's very deferential to the state air program, depending on the unique state air program needs, as long as it's above that presumptive minimum calculation.
Thank you. That's, do you have anything else? Thank you, Mr. Hearing Officer. That's all we have for cross-examination of the department's witnesses.
Okay, thank you. Mr. Rose? Yeah, I believe there's an extra. You could step up to the yes, and I believe there's an extra microphone.
Thank you, Mr. Hearing Officer. I have a couple of questions, Ms. Intermont, concerning her testimony, and it's more in the nature of clarification. And I'm referring to discussion on page 3 of your testimony. Looking at the first full paragraph that talks about AQB's FY24 state revenue funded annual operating budget. It's at the top of the page. If you need time to find it, go ahead and take it. It took me a while to find it too.
What exhibit is it, Luz?
10, I think.
Yeah, it's her pre-filed written direct testimony, page 10.
Thank you.
Okay.
And the question I had in terms of the numbers, where you said that the FY24 annual operating budget has increased from 9.3 to 13.6. Is the 13.6 the FY24 operating budget or the FY25 operating budget? It wasn't clear exactly when it went from 9.3 to 13.6.
Right.
You're talking about 24 to 25,
Right.
or the 13.6 being the 24 number.
It's to, it's to 23, fiscal year 23. So when we collected this data, it was all preliminary at the time for 2024. So that's why you see the blanks here in the, in the green shading. of the chart.
I'm looking at your exhibit 10.
Oh, okay.
I mean, it's NMED exhibit 10, but it's your pre-filed written testimony.
Okay.
Sorry for the confusion. I was just going off your written testimony, trying to understand what the sentence that you had at the top of that page meant. And I can read it to you if you want. Probably better if you find it. And my question was, is the 9.3 million, is that the FY24 budget? When you talk about increase from 9.3 to 13.6, with the 13.6 being FY25, or is the 9.3 the FY23 and the 13.6 the FY24?
Yeah. The 9.3 is actually, I think that's FY 2015. And then the 13.6 is calendar year 23 from the data chart. So my statement here, FY 24, it's confusing, yes. I'm actually trying to say over time from fiscal year 15 to fiscal year 23, our operating budget went from 9.3 to 13.6.
And my understanding will, starting Monday, you'll be operating under FY25 budget.
Correct.
Do you know what the figure is for the operating budget for FY25 for this program? Is it in the testimony somewhere?
It's not in my testimony. I'd have to defer that to Michelle.
Other than the 17 million, I think, that we talked about earlier in the strategic plan, I don't know about I think the operating budget. I might have to defer to my colleague. It's 17 million. Thank you.
And my understanding of the process is that your operating budget has to be submitted and approved by, there's an appropriation from the legislature, but the actual operating budget is proposed and approved, I think, by DFA prior to implementation. Is that correct?
Yes.
And the 17 million is the DFA approved number? Is that what I'm hearing?
I think so, yes.
And do you know how many FTEs you're authorized to have under that budget?
Under that budget, I think it's 108. I think our strategic plan says 110.
Okay. And I take it you're in the process, or will be shortly in the process, of preparing a budget request for FY26. I don't know what the deadlines are when you have to submit it to the executive and to the LFC prior to the next legislative session. Do you know when that timeline occurs?
September.
And is it the department's intention to, if these rules were adopted, to propose both FTE and budget increases as part of that request?
Yes, we're actually going to, we're preparing, and this hasn't been decided yet, but this is what we're meeting on next week on Monday. We're preparing a request to increase our budget for FY25 in order to meet our spending plan, which is what happens between our agency and DFA. And so we're going to be increasing that. And then depending on the outcome of the hearing, will be, it will really depend on the outcome of the hearing, what we're allowed to request in fiscal year 26.
And ultimately, it's my understanding that those are requests that then have to be acted upon by the legislature who appropriates the money. And my recollection is the Appropriations Act, or House Bill 2, not only delineates the amount of the appropriation, it also specifies the FTEs that are authorized for the agency as well. If the legislature decides not to increase your budget or the number of FTEs you're authorized, what's the agency plan to do? Are you going to get back the money that you're collected that you're not authorized to spend?
Well, I think that we're going to be requesting money that we need to spend very shortly in this fiscal year. We have the authority to create, and we'll have to create through the system, as many FTEs as possible. Of course, our state system is, for creating positions, is not known for its speediness. So for the remainder of the funds that we will be unable to spend on FTEs, we are preparing to use contract support while we're able to build out the FTEs to make sure all the work that we need to get done gets done.
Does the authorization to use monies for contract support, does that have to be approved by the legislature as well? Is that part of the Appropriations Act and the budget that you're approved? Or can the agency just decide to use the funds for contract support?
Well, we definitely have oversight from the legislature on what we do and what we, are able to do. We have the ability to create, the specific term is a budget authority request, or a BAR as it's known at the agency. And so that's really where we ask for the authority to do what we need to do. The legislature also sees the same numbers we do as far as compliance rates. And so our performance measures that we are reporting to them are below what we would like to see. And my guess is what they would like to see as well.
And those reporting, that's done periodically to the LFC. Is that what normally?
Correct. Yes.
And on what kind of schedule are you? Is that once a year, quarterly? It's
quarterly. We also provide our own agency-specific reports in addition to our reports that we provide to the LFC for further transparency in numbers so that everybody can see where our program's at.
And are any of those reports included in the exhibits you submitted?
We reported some of the information from those exhibits. I know that there's one exhibit, I don't recall that we submitted it, but I believe it was submitted by either the Mining Association or the Independent Petroleum. Okay, it must have been the Mining Association. That was an example of one of those Legislative Finance Committee reports.
And another clarification question, and again, Director Miano, if you want to answer, or Ms. Nindermont is appropriate, whichever one whoever gets a short straw can answer. When you're talking about, again, operating budget, are you looking at direct costs or direct plus indirect costs? What are we talking about in terms of that number? Is it just the direct cost that makes up that number, or are you including indirect costs as well?
It is both direct and indirect.
For the board's edification, when we're talking about indirect cost, what personnel is included in the indirect cost pool?
It would be, it's administrative services cost. So we have an administrative services division. They do a lot of our financial work, keeping our financial records. They do our contracts. It's also includes payroll. I believe it also includes our information technology costs with our NMED, as well as I think DoIT is actually separate, but yeah. So.
And that's referenced, I think, in in your exhibit 50, which is the EPA letter setting the indirect cost rate. Is department management, the division director, the deputy directors, the secretary, the general counsel, deputy general counsel, et cetera, are they included as part of the indirect cost pool, or are they directly funded?
They are in a different category than we're in. We are in this is going to get really wonky. We're in the P570 code. And so we fund P570 programs. The Office of the Secretary is in a different code. And there is a separate stream of funding that funds the Office of the Secretary.
And so none of these fees will go towards the funding of the Office of the Secretary. Is that what you're saying?
That's my understanding. Oh, no, wait.
Do.
It's trick. Yeah. Yes.
Okay. What about the general counsel's office? Are you funding the attorneys assigned to air quality directly, or are they part of the indirect cost pool?
Direct. As you can see, I have the financial team here as well.
Couple other questions, particularly with respect to implementation of the new NSPS, Quad O, Quad OA, E, et cetera, that applies to oil and gas. My understanding is that that's a delegated program under the Federal Clean Air Act, and the state would have to adopt those regs or something equivalent to those in order to get the delegation from EPA. Is it the agency's intention to propose to this board adoption of those NSPS rules and to seek delegation of that program from EPA?
Yes. Yes.
And as part of that demonstration for delegation, are you going to have to demonstrate the adequacy of the program, particularly in enforcement, to meet those requirements? Or do you know if that's going to be part of the demonstration you'll need to get that delegation?
Due to lack of staff capacity, I'm unable. We have not been able to spend the amount of time that we need to on developing the plan for implementation of those new rules. But we are starting to now, and hopefully with the fee increase, we'll be able to get started on it right away.
And do you have any sense of how those rules differ from this board's adoption of Part 50?
Well, that is a great question because although the rules, the new federal methane rules, which is Quad O, B, C that we're discussing, there was a statement made by EPA that they were modeled on the rules passed by the board, which is, in our opinion at the agency, pretty amazing. Unfortunately, there are some differences between our rule that we passed and the EPA model rule. So that is causing us to do some work to kind of evaluate both of the rules to see what would make the most sense for our oil and gas regulated entities here.
And in any case, you'll have to come back to this board either to adopt the NSPS or to amend Part 50 as a part of that process, correct?
I really hope we do not have to amend Part 50, but fortunately for the Quad O B, Quad O C, there's enough similarities. So stay tuned for what we'll be proposing on that. But yeah, it's a huge rulemaking that we'll be going through.
And do you anticipate that happening in the next fiscal year, or are we looking at, God forbid, FY26? Sorry. Seems strange to be talking in those terms, but I'm curious if.
I do not know. It depends on what we're able to fund.
Let me turn to ED Exhibit 15. And this is one I had a question about early in this proceeding. And it's a memorandum dated June 6th, I think. June 5th, excuse me, from
Okay.
ERG, the
Yes.
Air Quality Bureau. And I'm looking at footnote 9 on page, yes, these pages aren't numbered. The next to last page, it looks like. It's footnote 9 in any event. And both the text and the footnote that's referenced talk in terms of total number of new facilities to be regulated under Part 50. And it said that was information provided by the Air Quality Bureau. Is that information or that transmittal of the information included in any of the department's exhibits?
I'm not sure I understand. This is a department exhibit.
Yes. And so.
Yes.
And what I was trying to figure out is the basis for that number. I think it's 55,000 new facilities regulated. Is that explained anywhere in terms of how that was derived? I couldn't find it. That's why I was looking.
Yes, that is what our air program projects. We will need to address new facilities under the phase-in of Part 50.
And does that number represent 55,000 per year or 55,000 total based on what's currently in existence?
Total of new facilities coming online.
Now I'm confused. New facilities meaning not yet constructed and to be added, or facilities to be included in the program and weren't otherwise included in the program?
My understanding is that from the air program that there's going to be 55,000 new facilities.
That's per year, or just 55,000 at the advent of the program?
Advent of the program.
Okay.
Excuse me, sorry.
And does that represent primarily the number of oil and gas wells subject to the rule? Is that the vast majority of that number?
Yes, it's a number of sources.
And do you know how many of them are subject to NSR permits, either site-specific NSR permits under Part 72 or GCP oil and gas, or the other GCPs that are applicable to oil and gas facilities?
I don't know. And that's going to be dependent on our, all of this is our best number forward. All of it's going to be dependent on what our attainment designation is in areas that are currently showing non-attainment.
At least areas that measure in excess of the federal ambient air quality standards.
Exactly.
Not yet, not attainment, at least. Last I knew, the administrator hadn't yet designated the areas as non-attainment. If in fact, and I think there was some discussion about the number of GCPs that were issued. It's my understanding, and you included a copy of GCP oil and gas, that if the area in the southeast, basically Lee and Eddy County, are designated non-attainment, that GCP will no longer be applicable, correct?
We hope that's not the case, but we do not know yet. That's what we're evaluating right now.
I think it says on the face of it, doesn't apply in non-attainment areas, is my recollection.
That's mine too.
And we actually had a case in front of the Court of Appeals dealing with what non-attainment area meant in that context, if you recall.
Correct.
And so it'll take designation. Once there's designation, no new GCP oil and gas will be issued. Whether or not the agency, I take it, can amend it, adopt a new GCP in the non-attainment areas soon, I guess, to be determined at this point. That's the review that you're currently doing, correct?
Correct.
Do you know what happens to the existing GCPs if the designation occurs?
No.
And is the process for developing new GCPs or amending the existing GCP included in the strategic plan or the workload the department's envisioning to be accomplished in the next fiscal year or so?
That's a good question. It depends on what our analysis demonstrates as far as what our attainment designation is going to be. So for non-attainment, there's a range between marginal and extreme. And so based on the monitor readings, we anticipate being a marginal instead of a moderate, but each designation carries with it different directives to the department. And of course, we need to make sure that we are addressing the issue of ground level ozone pollution and trying to get those numbers down. So we're determining under different scenarios what the different ways are that we can do that. And depending on that, we'll determine, one of those options is continuing with the GCP program and modifying it because it does say not available in non-attainment areas on the face of it. So that is part of the heavy lifting that the air quality program is doing right now on top of all its other day-to-day work. If the GCP is not used, then the NSR permit will have to be used, which I know is not favored by the oil and gas industry and requires much more intensive modeling. So we anticipate a lot of workload under any of these scenarios, and we just have to determine where to direct our energies after we evaluate all those options.
And I take it the GCP and its content are solely within the discretion of the department at this point. The board's regulation 20.2.72 basically allows the department to issue GCP. So the decision on whether to issue, how to issue them, who it's encompassed is all within the discretion of the agency at this point.
Yeah, I believe it's reviewed by the secretary.
But it's still an agency action, not a board action. Wouldn't require this board intervene. Do you recall, as part of the ozone precursor rulemaking, the department's preparation of a plan to limit ozone pollution? That was part of the department's submittal and part of the board's review of the ozone precursor rulemaking.
I can't speak to the details of the record, but I know that the department was following the statutory directive that required the agency to act if we're in 95% of the acts of the national ambient air quality standards for ozone. And so I don't know if that is the preparation with the methane advisory panel and such.
There's actually an exhibit in the record, the department designated as their plan, which the statute requires. I'm just curious if you've looked at whether or not a non-attainment whether and how a non-attainment designation or redesignation, I guess it would be, would affect that plan and what kind of amendments. I know you have to develop a non-attainment plan to submit to EPA, but you have a plan that exists already, and I wasn't sure. I was curious at whether the budget you're proposed includes starting from scratch or whether you're looking at using the existing plan as a basis for development of the non-attainment plan to submit to EPA.
We haven't had a chance to look at the plan to make that determination, but regardless of what currently exists, we have a lot of work to do to determine what pathway to choose. And we know it's very consequential for industry, so we're not taking that lightly.
For purposes of this rulemaking, and I can't remember finding it in the documents, but I could have missed it. Have you laid out what your proposed, not budget numbers, but what staffing would look like? I know you talked about numbers of personnel, but have you laid out how many managers, how many, engineers, the different classifications you would need to implement this program?
For our fee proposal that we've presented to the board, all of our numbers that go into the 30 million calculation, that is all based on doubling the program. That's what we've assessed so doubling all the FTEs and So anything that you see in our air quality program now, times 2.
And so you haven't gotten to the point of, you know, and maybe this is too fine a point, but you haven't decided how many, you know, how many permit engineers precisely you're going to need and at what classification, and how many managers you're going to need, at what classification. That's all to be done once the authority has been granted. And once you start receiving the funds, you'll start putting the details of the program together.
For the permitting program, well, did you know how many? I think it's 30.
As far as the,
I believe it's 36 in the permitting program, or 30 in the permitting program. Yeah. And so we would have, you know, if we have environmental scientists, 6 environmental scientists, it would be 12. You know, we have 3 supervisors, it would be 6. So that has been our calculation for addressing our workload.
Okay, and at some point, you'll be putting the detail together. I take it you'll have to do that to submit it to DFA and the LFC when you start looking at budget authorizations and FTE authorizations, correct?
Correct. And also depends on if we don't receive the fees from our proposal, we have to develop a new plan. And so that will probably look extremely different to try to adjust for our workload.
And I take it you're looking at least if I heard the testimony correctly, you're looking at both hardware and software acquisitions in order to implement this, some to replace existing hardware and software, others who may need new hardware or software to implement this. Is that contained anywhere in any of these exhibits, or is that still to be determined as to what the contours of that are?
Well, we've made some preliminary, we have done preliminary research to inform our request. And so it escalates pretty quickly. Our tempo program right now, as everybody has heard, I think over and over again, is very old, and it will require, at the very minimum, we've determined $3 million to get up and running. And so that would probably be a cost that we'd have to absorb, whether it's data specialists that we hire to help implement the program, working with air specialists to ensure that it's built the right way. And all those details are still up in the air.
My recollection is Tempo is in essence a program or software the agency purchased that was in use elsewhere for air permitting in other states. Is that what you're contemplating doing, or you contemplating trying to develop specific software for New Mexico?
We definitely want to stand on the shoulders of giants. We know there are a lot of programs out there that already use up-to-date software. My understanding is when we acquired it from other states, Tempo, it was already 10 years old. And so we have been talking to other states as part of our national, network of state agencies. And we have received some great information when it comes to all different kinds of programs that we can use to kind of get to those principles that we're seeking to achieve in our upgrades.
And is there an administrative process in addition just the agency review you're going to have to go through? Is this either the software or hardware acquisitions? Does that have to be part of a plan that's submitted to and approved by the Department of Information Technologies, or is it something that ED can implement without oversight from DO-IT or from DFA?
Well, we definitely need oversight from everybody that looks at what we're doing, including DO-IT and DFA. I think that for ours, we haven't chosen a system yet. And so it depends on, sometimes state agencies already have existing systems or a different folks on statewide price agreements that, we can utilize. Those details are pretty up in the air at this point.
And there's a procurement process. You'd probably have to go through the procurement code and do, I assume, an RFP or whatever the the process you'd have to look at under the procurement code before this could be done. Do you have a timeline for what are we looking at in terms of decision-making on this and then subsequent implementation? Are we looking months, years?
Monday.
Can we hold you to that?
I will say we have a chief information technology person whose office is down from mine, and she has Tempo upgrade taped to her wall right now on her to-do list. So we're all waiting for the outcome of the hearing.
And I know these processes are never smooth and can be complicated and there can be delays. So just trying to understand, if you were to collect monies when this rule is implemented, how soon would you be expending them on those programs? Do you have a sense? We're looking at implementation this fiscal year, the next fiscal year. What are we looking at here? What's the likely outcome of all of that?
For development of the Tempo data, for a development of
permitting, so I guess it's Tempo basically is permitting software for the most part. So,
well, it depends on if we have the ability to utilize existing, programs and which program we decide. And hopefully with our fee increase, we'll be able to hire folks that are, one of the challenges that we face a lot of the times is there's a lot of data scientists, but they don't have air knowledge or knowledge of the Air Act to kind of help inform what some of the basic decisions are when we create the program. So we do not want to create we don't want to create a program without our air scientists, because they know the best how data should be presented. And so it kind of depends on which program we choose, but my goal for the program, and I know this, I'm sure, is everybody's goal in the air quality program, is to have it up and running in hopefully by the end of the administration.
which is what that's year after next. Is that what that is?
2.5 years.
2026. What about hardware? I know you talked about monitoring data, having air quality monitoring data. Is that, or at least the equipment, does that also have to be capitalized and submitted to, is that something you'll have to submit to the legislature for authorization and approval for funding that? Is that something that's done internally?
So I oversee the monitoring program. No, that wouldn't be something that has to be decided by anyone other than our procurement officers. Depending upon the purchase, the vendors that are selected and all of that. Yeah, that would all be in-house.
And is the agency considering asking for an appropriation from the legislature to specifically update that equipment or expand the monitoring network that you currently have?
No.
Okay. Is there a reason why you've chosen not to go to the legislature as opposed to asking for a fee increase?
We have been trying to go to the legislature to put Band-Aids on our program. So we have had a couple of special appropriations, but the directive we've received is that the Air Quality Control Act requires fees to be set in fee schedules by the Environmental Improvement Board so that we can fund our programs and not seek legislative funding, with the idea being, and this is true, I think, under the Air Quality Control Act, that the pollutants, the entities that are polluting, are the ones responsible for paying for the air pollution prevention program. It shouldn't be general fund or fund from the individual taxpayer that would contribute to that. The policy intent is that it comes from the polluters themselves.
We may not agree as to what the actual policy is and what the discussion is with the legislature. Is it your testimony that all of the expansion that you're looking at can be funded by these fees? So everything you're asking for can be attributed to the fee increase, and it's within the board's power to fund those expansions.
I would say that generally, yes. There from time to time, there are some monies that we get from the general fund, but largely it is the responsibility of the board to ensure that we have under the Title V program, under the Clean Air Act, and then under the Air Quality Control Act, the reasonable amount of fees from the construction permitting program to make sure that we're able to do what we do.
And you still have, I take it, a 105 grant from EPA. Is that, if you take delegation of the NSPS Quad O, B, and C programs, is there any expectation that there will be funding from EPA along with implementation of those programs? Is that still up in the air?
No, actually, the Environmental Council of States has this as a primary issue. So the Environmental Council of States is all of our state environmental agencies, bipartisan, that work together to ensure that there are common issues brought to whoever needs to hear them. And one of the issues is that generally state air agencies are severely underfunded, especially with in the past couple years, all of the new regulations that are coming down from the new power plant rule to the new methane rules. And so none of those rules come with any kind of funding attached to implementation of those rules. And so, EPA's letter supporting our fee proposal that was submitted last week, I think is an indication of that recognition that it's asking state air agencies to do a lot, and we don't have the resources to do everything that they're asking us to do.
And I take it if you don't have the ability to perform those tasks, EPA will be required to do that, correct? Under their budget. I mean, they'll have to implement the NSPS. It's their rules.
That's a good question. I think that remains, we do not generally as a state agency want to have a federal implementation of any rules. We want to have the control here. And so that's why we're working so hard to ensure that we can develop our rules in the way that we think makes the most sense. So we're trying to avoid the EPA coming in.
And well, the rules will be applicable either way, whether the EPA adopts them or the state adopts something and takes delegation, right? The rules will be applicable.
Yes.
Has the state refused NSPS delegation in any of the air programs?
Not to my knowledge.
I think you have for radiation, but is that a decision that the department makes? Is that a decision that the board will have to make in terms of what's submitted to EPA?
Can you repeat the question?
In other words, you have to come before this board and potentially adopt rules that will be where the subject, if the rules are adopted, whether delegation is appropriate or not. One of the options potentially the board would have would be not to adopt the NSPS and therefore not take delegation. So that would be a board decision at that point. And I take it you'd outline the staffing necessary to implement that. That would be one of the decisions or an element of the decision the board would have to look at in terms of deciding whether or not to adopt the regs and pursue delegation of that program, correct?
I don't know can you repeat the question? Sorry.
What I was getting at is that as part of the board's decision to adopt NSPS or to reject a proposal, they could consider the cost of implementation in their decision. If they decide not to, that there's insufficient funds or it's inappropriate to implement, they could decide not to adopt the rules, and therefore the agency would be precluded from seeking delegation, correct?
I don't know that to be true.
One of the key elements is that you have to have rules in place that are at least that are either equal to or more stringent than the federal rules that you're implementing. If the board decides not to adopt the federal rules or something equivalent, you obviously can't make the demonstration that you meet the equivalency test.
Oh,
There-
got it.
therefore,
Yes,
it could
sorry.
be
Yes, thank you. Sorry.
That would
It's been a long couple hours.
you just wait. We may be doing this tomorrow too, unfortunately. You won't have to be sitting there, so it won't be quite as, although it may be more. Anyway, we'll get to that later. See if I can. I think that's all the questions I had, Mr. Hearing Officer.
That gets us to in the proceedings where the board members ask questions. Ms. Ely?
Good afternoon, NMED team. Thank you for your testimony, written and oral. And I'm still struggling a little bit with the numbers as far as operating budget, what you currently bring in with fees, NSR and Title V, and what the proposed increase would bring us. Am I cutting out or is this okay? It's okay. Okay. So it looks like under Ms. Intermont's testimony that you currently bring in about 13.6 million in NSR and Title V fees. And your goal is to reach 30 million. In the ERG memo, you say you need another 13.4 million to get to that goal. It looks like there may be a little bit more than that to get to 30 million. Is that correct?
I'm sorry, can we, or is this, I'm sorry, Member Ely, is this in the ERG memo?
Yeah. Yeah, Exhibit 15. There's no page numbers as noted. But at the penultimate page, and maybe even on the last page, in conclusions, it says that in order to bring on 103 additional FTEs, you need $13.4 million annually.
Oh, got it. Yes, for this report, the 103 additional FTEs. I see what you mean. This is a little bit confusing. So the 103 additional FTE staff positions are estimated to cost, yes, more than 13.4 million annually.
It says approximately 13.4 million. Are you saying it would be more than that? You just look on the very last page. It summarizes it under conclusions and recommendations.
I think it's one of the bulleted items on the bottom.
Okay. So yes, it's approximately 13.4. So 103 additional FTE staff positions at the estimated cost of 130,000 per FTE is approximately 13.4 million.
Okay, great.
Sorry.
Okay, so we're getting on the same page. then.
Yes.
All right.
And I
And-
see it in the bullet.
Okay. And so that's just for the FTEs. That doesn't include some of the technology upgrades or the doubling the space that you're going to need to house all those folks,
Exactly.
the cars, the training, et cetera. Okay.
Exactly.
So that may be part of the difference between the 30 million, your current fees, what they bring in, and the 13.4
Yeah.
additionals that you need. Okay. Okay. So of that 13.4 million that's needed on an annual basis, how much of that under your proposal would come from the increase in Title V fees?
For out of the 103 additional FTEs, it would be, we're projecting about twice the amount of Title V personnel and upgrades. And so that would be, let me get my calculator. I believe it's about 6.5.
6.5. And then how much from NSR fees? Or do you just,
Just the remainder.
yeah. So another 8 million in NSR fees.
Yes.
The memo also describes how you estimated the 103 additional staff. It's a little confusing to me. Could you summarize how the added enforcement staff and how added staff are needed were determined, the number of added staff were determined for the Part 50?
Mr. Hearing Officer, let me restate my objection to the admissibility of this exhibit. As I said, the detail that went into it is not available for us to examine and to cross-examine. I think we're now getting into the justification for the numbers. It's not in the documents. And so we've had no ability to review or to comment, or in fact, to examine the witnesses as to the basis for those conclusions.
I'm going to allow the questioning with the recognition that this is related to an exhibit that the veracity of which has been questioned, and we'll go along with the questions, get whatever answers we can get, and then the board can give the weight it deems appropriate to the answers, given the fact that the exhibit has been questioned.
I'm sorry, Member Ely, can you repeat your question?
Yeah. So there were two estimates here. One talking about calculation of needing 21 more FTEs to support the increased NSR workload. The other is for implementation of Part 50, requiring another 82 FTEs. There's some assumptions in there that may or may not make sense. And so I'd appreciate it if you could just summarize how they came up with those two FTE totals, 21 and 82, and specifically address the assumptions about the number of hours required to do the work.
So for this report, we have estimated the average FTE cost, the number of permitting actions, the average number of NSR permitting actions, and current AQB staffing. We are really, this is just a projection, but we're really looking at doubling that number. And so, for example, We know that our current AQB staffing is about 20. And then so for the additional FTEs, we're doubling that as well, just because of the workload. And that is across each of the sections.
Under the calculations to implement Part 50, it says you need 12 hours for review. What does that mean? 12 hours to review each of those permits, applications? And how did that number get into the calculation?
My understanding is this was from the staff, about 12 hours per source, per facility. And that with the additional 55,000 facilities, that is the number, that would be the number needed, would be the 82 for review and enforcement.
Okay, I was just looking at the 12. In past fee hearings, we have, the Air Bureau has done detailed calculations on assessing the amount of time it takes to review and do different tasks. How much time does it take to do a GCP for pressures, for example, or how much time does it take to do a PSD permit? And when they did that, they came up with the fee structure, the fee-based structure, which makes a lot of sense to me because those more complicated permits should be paid more. The industry should pay more for them. And so I'm just wondering, how did you come up with these numbers? Are they WAGs, or was there a detailed analysis to determine that it actually took 12 hours to review? I assuming that's a permit application, I don't know, and 173 hours to enforce. Was that based on a detailed analysis, or how was that number determined?
I know that we do use estimates for each of our permits. These numbers were provided to us by the program with our ERG contractor. And I think it might be worth calling in our ERG contractor to determine what those assumptions were, because they were conducted in consultation with AQB staff. And so I want to make sure I'm getting you the right information, Member Ely.
Okay, thank you.
And again, Mr. Hearing Officer, if the department's going to provide that information, I think we agree it probably would be necessary. Under the rules, that should be provided in written direct testimony with the opportunity to file rebuttal in the context of this hearing. That wasn't done. Now, it can be cured if you want to do that, but if you're going to allow your NMED to supplement the record based on ERG testimony, I asked that the hearing officer to give us the opportunity to put it in writing, give us the same opportunity to review the testimony, prepare rebuttal, and to prepare cross-examination on the ERG witness that we've done with every other department, direct and rebuttal testimony witness.
Let's see if the contractor and a witness is made available. And I'm going to ask the department to make a request as to how we should, make a proposal as to how we should proceed in terms of presenting that witness's testimony. I would note for the record that Mr. Rose's comment is well taken. There needs to be some kind of a process. If you're going to bring in a witness in the middle of a hearing or want to supplement the record, we need to establish a process for allowing the other parties to review the testimony and prepare cross and possibly submit rebuttal. Yes, go proceed.
Okay. Okay, thank you for that. The proposal to bring on 103 staff is a lot of additional staff. Having worked in the department, I know how difficult it is to hire, to create positions. Do you anticipate any issues with the legislature granting that large of an expansion request? And do you intend to do it in one legislative session or over time in multiple legislative sessions?
It would have to be over time, and it is a large number. We recognize that. Uh, it is also a large amount of work that we are unable to get to, and a lot of um, technology that we've been unable to integrate because the consumer price index, based on everything that's happened over the past 20 years, hasn't kept up. And so our approach is this is a baseline reset, and we can continue to use the consumer price index, and that this will help cure that. As a practical matter, we're going to phase in those FTEs over time, and that for the remainder of the funds that are not being used to fund FTEs, that will be used for contractor services. And so, for example, for FY25 and FY26, and for the remainder of the administration, we've projected, how many FTEs that we need to meet our 103. But it is going to be a process in order to phase them in.
Over how many years do you anticipate you'll need to create 103 new positions?
I'm hoping our projections that we have utilized is about 3, because that is, the remainder of the administration here, and we're not quite sure what would happen with the new administration coming in and what policy direction they would take. And so in recognition of that, the department is acquiring new building space, because with all of those new FTEs come the needs for additional seats and desk space and office space and laboratory space for them. We recognize that it is a lot, but there's a lot we have to do.
Considering that salaries make up about 80% of your budget and you're phasing the FTEs over a 3-year period of time, did you consider also a gradual increase in funds so that your fund balance doesn't get too large? Title V fund balances can't be swept, but NSR fund balances can. So are you not concerned about that? And have you thought about phasing in the fees rather than one shot?
We have not considered phasing in the fees. We are proposing the one shot because we need that shot in the arm for the hiring and the work that we have to do immediately. And so that was our thought with our proposal here.
Another conclusion by ERG is that you should, at a minimum, increase the fees for Title V to the presumptive minimum. Did you assess the revenue generation for the Title V program at the current presumptive minimum of $61.73 instead of $81 a ton?
No, we used 81 per ton of allowables. And so the presumptive minimum assessment is not something that we can rely on.
And did you also do a calculation leaving the 6,000 ton per year cap in place?
No, our understanding is that back when the fees were originally, or the last time the fees were addressed, there was only one entity that was above the 6,000 per ton cap, which is the San Juan Generating Station, which has since closed. I know that in Freeport's exhibit, they say that they're a little bit above the 6,000 cap if you address their particulate matter, but it's not much above the 6,000 cap. And Member Ely, if I may, I have been advised by my colleague that for the assumption going into the hours for review, that 12 hours is for the additional review on top of an actual permit review that Part 50 will add. And so that is on top of the calculation that we already utilize, that my colleague Melinda Owens can speak more to as far as, assumed hours per permit. And so I'd like to make that clarification for that assumption.
Ms. Owens. As I noted in previous hearings, the Bureau analyzed the number of hours required to conduct certain tasks and use that information to inform the point-based fee schedule. The point-based fee schedule that we're talking about for NSR, right? What analysis did you do to determine that a 5-time increase in the points assigned to oil and gas GCP was the right multiplier?
Okay, sorry. I was not involved in the initial project with the proposed fees. However, I've been told by our minor source managers that the time required to review a GCP is comparable to the time effort to review an NSR. There is no shortcuts. And they are required to do a full analysis to ensure that they cover every aspect of that application. And I discussed that in my oral testimony earlier today. And so because of the comparable time, I can't really address the proposed fee. And I don't know, Donna, do you have any input on that? For the GCP? No. Do you, okay.
I don't have anything else to add for the points for what Melinda said.
Okay. I'm just wondering if would 3 be a reasonable multiplier? I mean, it,
So I don't know.
yeah.
For our purposes, when we were putting together what we would need, it is essentially determining the funding and the personnel that we need to process all of the GCPs and the regulations, the monitoring, and the upcoming non-attainment, and determining what we would need underneath the GCP in order to meet that amount.
Yeah, got it. I just want to make sure it actually reflects the work involved to do that, because that's what the fee-based point system is about, is reflecting the work required to do those individual tasks, and is 5 times the right number. And again, was analysis done, averaging the hours it takes to do a GCP over time to determine that 5 was the right multiplier.
I can speak that, Member Ely, too. From what I understand, there were original projections done that determined the amount of hours and time for those GCP permits that were extremely inadequate by an order of magnitude as well. And so the increase reflects what the program has been experiencing as far as the work and hours to put into it.
And so our two minor source managers say that it requires every bit of the same time and effort to process a GCP compared to an NSR. Plus the additional fees will allow us to increase some staffing levels instead of having to contract out. We are just on the border of not being able to sustain meeting the deadlines, the 30-day deadlines on the GCPs, even with the help of ERG. And they have, every week we call them and can you take any more of these applications? And right now they've agreed to take 10 a week, but we are, at some point, we probably are going to start missing deadlines on the.
Thank you. Mr. Peters, regarding the modeling, I have a similar question for you. How did you decide that doubling the number of points for modeling was the right multiplier that reflects the staff level of effort to do that work?
Unfortunately, we don't have exact numbers of how long it takes to review each modeling project. We did come up with a tiered scheme of offering different number of points for different types of modeling. But after we proposed that, we determined that it was just too complicated for the amount of time we had to come to this fee hearing. So it was proposed that we use 50 points. And I suggested that we use 30 instead of 50.
Thank you. And then Ms. Entermont, something for everybody here, right? Your direct testimony summarizes how Title V sources are currently billed for allowable emissions. And so I have a question on the timing of that if the board adopts a new rule. So if the board does approve of the Title V fees and the rule goes into effect July, will it apply to allowable emissions generated by industry for the whole 2024 calendar year and reported to the Bureau by December 31st? Or will you bill for pollutants emitted prior to the effective date at a different rate for pollutants emitted after the effective date? Have you thought about that?
That's a good question. If it is effective in July, then we would have to do I guess, figure of from July to December 31st as one, I guess, calculation, and then do from January to June 30th as the other, and somehow then apply that to the, as one Title V fee, and I mean, add it together, I suppose. It would be, I didn't think it would happen that soon, but that would be great. We definitely find a way.
I just wanted to make sure you weren't charging industry for pollutants that have in the first half of the year at a higher rate. That's all.
Correct.
Yeah. All right. Thank you. That's all my questions for now.
Thank you, Member Ely. Other board members? Member Garcia.
Thank you, Mr. Hearing Officer. I have several questions as well, and I'll let you all decide who is best to answer the question. I think this might be for Ms. Miano. You're talking about doubling the program, basically. You're talking about doubling these programs and hiring all these FTEs, 110. Was that the number you're striving for?
Yeah, between 103 and 110. Yeah.
Okay, okay. And you currently, as I recall, the times that the Air Bureau has come before this board, there's always been a persistent vacancy rate in the Bureau, and it's a big problem, I know. Causes even more work for staff. So as long as I can remember, there's been a terrible vacancy rate, hovering around 30%. Is that about right? I'm wondering, what is your plan for hiring more FTEs when you can't fill the ones that you have open now?
That's a great question. One of the factors that we're projecting is going to change that is the increase of salary that we have been able to achieve for many of our air quality bureau staff that were not in the past paid based on their education and experience. One of the issues that I have heard since working in the agency is that our wages aren't competitive enough and there are other jobs out there. And so we anticipate and word has gotten out. I know a lot of the other state agencies are rushing around to see what they can do to follow our lead. We hope that our increase of salaries based on what people are worth and are competitive will make job our job spaces more competitive for people looking for jobs. One of the other things that we've done in the agency over the past couple years is we have started an internship program. And so we have been bringing in interns. I have a wonderful intern that the department has who sits right outside my office and really bringing in folks when they are right after school and making sure we can bridge that gap. So really leaning in on bringing people in and, training them through our state teams. The other thing I would say is for vacancy rate, we have really at the Air Quality Bureau and in my division have brought on ways to invest in our managers and supervisors in ways that really haven't been available before to really empower supervisors and managers to grow and develop teams. And so we have been embarking on leadership training for all of us, myself included. And we also want to make sure that one of the things that we also know from feedback is that the satisfaction of a employee coming into the Air Quality Bureau, when they come in, they have this great degree, they have an engineering degree or a science degree, and they come into the agency and immediately they are trained on an access database, right? And so there is a frustration element that comes sometimes with working in our bureau because we are trying to use systems that are frustrating. And so we do not have job satisfaction because, as I alluded to in my direct testimony, you have the emissions inventory portal breaking down and everybody is completely stressed out because we don't have the IT capabilities to ensure that regulated entities can submit that smoothly and people are stressed. So I think that by providing some of the upgrades that we're talking about today, that in turn provides a satisfaction when the employees know that we're hearing them, that they need more resources and they need more upgrades, and we're providing that to them. I don't want to bring on employees and immediately put them in front of Tempo or an access database. I want to have them immediately working on projects that will be that people can get excited about and that can make their jobs easier. And with our managers and supervisors, have them be the leaders and empower their own teams and hopefully get some of those vacancies filled.
Thank you. Another question. You all mentioned you have deadlines, you have to meet statutory deadlines, et cetera, for review and permit approval, et cetera. And that you're concerned you may miss deadlines. Have you missed deadlines in the past?
Okay, it's a rarity. We just, uh, it's a very important aspect of a permit writer's job. They are actually evaluated on meeting those deadlines. We have met them, with the exception of an occasional, an EPA petition or EPA order. We are making all of the NSR deadlines at this point, but it's just a matter of time that we will not be able to.
And what would be the consequence of missing deadlines?
Well, certainly, it depends on which program it is. The Title V program, we report to EPA twice a year, something called the TOPS report. And we're required to do an adequate job, meet the deadlines. We tell them how many permits we have in-house, the Title V universe. As it happens right now, we do have about 8 Title Vs that have been sitting for about a year and a half because of an EPA order, and this is to resolve the issues involved in that. We had hearings on those as well. And so, I mean, the consequences, we certainly don't want EPA taking over our Title V programs. This is our statutory deadline. We must make those for NSR. So we're going to be we're going to have our industries very unhappy. And you have something else?
Something else that I can add that we've been considering is I don't know, but I don't know if this would work, but one of the things that we've been thinking about is maybe like in the compliance section, we have tolling agreements. Like, could we toll statutory deadline? I don't know if that would work. But we want to be not delaying, we want to be solving the problem. And as far as our compliance, if the compliance program is any indication, we have a lot of tolling agreements, and we would rather be working on the cases than working on the tolling agreements. So for the permitting program, we would rather be working on the permits rather than working on like a tolling agreement type vehicle for trying to meet an agreement with an industry entity to extend those, agree that we can extend the statutory that I don't know if that would work, but that's just something we've been, as a practical matter, trying to brainstorm how to resolve.
And we do request extensions for NSR permitting actions. But generally it is something that it's not us not meeting the deadlines. There'll be some modeling issues. They can't pass modeling, or they have revised the application to such an extent that we need more time to review it. But that's not, we want that to be an anomaly, that not to be the regular case. And so we just want to do the correct thing and meet those statutory deadlines. So.
Right, thank you, I understand. Also, in terms of some of the things you're going to use this money for, I hear you loud and clear that you needed this yesterday. However, nobody's come to this body before asking for a fee increase. You probably can't answer this, but I'm wondering why in 20 years somebody didn't ask for a fee increase and then suddenly ask for this much of an increase now.
A lot of it has to do, I don't know the answer, but from a policy perspective, a lot of it has to do with policy decisions in the past and workload of the Bureau. So for example, in order to be here today, we all are taking time to step away from our day to day in order to do all of the preparation work and all of the testimony. And it's something that our administration has prioritized because they know that under any of the work that we do, we need to have the funding sufficient for it. And in the past years, there had been a decrease in funding, and I don't know whether there, and we have our secretary and our administration has slowly tried to build back up over time to funding where we once were in the past. But for purposes of being here today, I think it's I don't know exactly why in the past 20 years, but it does take a lot of work, and it really takes you know, a leader like the secretary to say, this is more important than anything else, and this is more lasting than anything else. And so that's one of the reasons why we're here, is because as far as lasting impacts that will make sure that the program can succeed into the future after my term ends, that's something we want to make sure that we're giving the programs the ability to run their programs with increased revenue. And so we're hoping that that lasts beyond whatever political wins may happen. And so that's the intent of being here now.
Thank you. Also, I know it seems like we have a lot of questions, but this is a big ask. You're talking about not just doubling, you're talking about tripling and quadrupling fees. And so we have a huge responsibility in making sure that we do our work to make sure that this is something that we should approve or not. So regarding all the work it takes to come before a board and ask for a fee increase or any rulemaking, I know it is a lot of work. I've been there. And I know that typically you all will go out around the state and do a lot of stakeholder meetings. And what I read in the evidence is that there was just one meeting. Is that correct?
There was one public meeting, and there were subsequent meetings with different interested stakeholders based on their interest in the action.
Okay. Did you make any changes to the proposal based on some of their comments?
We did not.
It seems like this is, as you said, the secretary said this has to be done now. So perhaps you didn't have time to do the normal process of going around the state with stakeholder meetings. Do you think that if you had done that, perhaps you would have a little better understanding from the industry as to why you need this increase? Do you think that would have been better to do?
You know, for as far as stakeholders, I mean, I think we have a lot of stakeholders, right? So as I referenced in my testimony, we have stakeholders that have brought a civil suit against us, right, for not having a program that's meeting the needs of the residents. We also know that we have a responsibility to make sure that our as much as we can, you know, either prevent ozone, you know, I think we are going to have an ozone attainment. I think that for purposes of meeting with industry stakeholders specifically, we, you know, had meetings with industry stakeholders. I think it does not feel good when costs go up. As we heard earlier, you know, costs for everybody has been going up over the past 20 years. Our cost going up has been very incremental, and it just hasn't kept up. So, you know, although we have meetings and we hear that there are concerns with the amounts of how these of the amount of fee increases, we also know that based on the types of industries that are not wanting us to pass, you know, not wanting us to bring the proposal, that they have been you know, having themselves increasing revenue while we have not. And we didn't expect them to agree with really any of this. I mean, we explained the intent behind it and why we needed to do this baseline correction, but it does not feel good to start, you know, for example, paying for the particulate matter that we haven't been charging for in the past. It doesn't feel good to see all of those costs increase, just like when you see your car insurance go up. You're like, oh, the insurance company. But for our purposes, it's really what's needed as a baseline, correct? We're not asking for increased fees over 5 years. We're asking for it all at one time, so that you know, there's not increased costs that are incurred by the industry. That's just one shot. We think that based on what we understand from, you know, example, the state and its record revenues from oil and gas in the Permian Basin, that the cost of doing business has gone up across the board. The cost of doing business with the state of New Mexico has not. And this is our chance to make sure that the department gets what it needs, and then CPI, you know, will be continued going forward so that there won't be those big steps of increases. And so there's a component to understanding and listening to what the New Mexico community wants from us. And there's also sometimes you're not going to have a meeting of the minds on what the program needs to be effective.
Thank you. I can certainly appreciate that. So just a couple of more questions. Going back to the use of allowables to determine your fees. I understand why you probably do it. It would be easier than going to actuals and then try to figure out. I mean, it would take more time. I understand that. I did see a table, and I don't remember whether it was an ERG submittal or which one, but of other states. And can you tell me if the surrounding states, Texas, Arizona, Colorado, et cetera, Utah, do they use allowables or actuals? Is this something unique to New Mexico?
It is something unique to New Mexico. I mean, there are different ways you'll see some of the states, and it was the ERG report, have a tiered system, but most of the states use actuals.
Thank you. Okay, and then one other question. This might be for Centermont. You talk about, you know, upgrading, needing more FTEs, doubling the program essentially. There's not a whole lot of detail. As you know, Ms. Ely, Member Ely asked some very good questions about details that I was wondering as well. You mentioned you need to upgrade Tempo into a better system. Do you know what database you want to purchase?
No, we do not. But the Tempo system they've had for a number of years. When I first came to the Bureau, I was a little shocked at the trying to use it. Kind of reminded me of an old DOS system, a little bit like tax and revenues, old driver system. I mean, it's very archaic. To pull any information is a major undertaking. Most of the staff do not completely understand Tempo. That's, you know, part of it, but it's a difficult system, and it's just not user friendly. Eric is one of the few that knows the system. So we're relying on really one or two people in the Bureau that can pull data. It's just frustrating. So
I understand. I definitely agree. You need a better system. There's no doubt about that. I guess what I'm asking is in terms of you're asking us to approve a fee increase to get $30 million, but you don't provide a whole lot of detail about what that money's going to be spent on. And so now what I'm hearing is you're not sure what a new system would cost.
Member Garcia, we have done preliminary work on how much the new system would cost. So we have met with our IT agency folks, and they estimate to get started, it would be, and this is not a completion by any means, but it's about $3 million.
Okay, thank you. And that's all my questions. Thank you very much.
Questions from other board members? Member Hunker.
Yes, just a couple of questions, and I assume from Ms. Miano, back to the hiring practicalities of 103 to 110 FTE. I would guess most of these positions are going to be technical positions, scientists, engineers, since this is very technical work. Does the talent pool exist with people who would be looking for work within a 3-year period where you could conceivably fill those positions?
That's a great question, Member Honker. We have been exploring all of the different recruitment tools that could be available to us to widen our pool and recruit from universities, maybe through that through internships, but also nationwide. I think that by using some recruitment tools, we'll be able to increase our ability to hire. And I think that one of the other factors that we've determined is there's a lot of concerned folks out there and a lot of folks looking to jump on the momentum. And so I think that when, for example, if the board decides to adopt our proposal, I want to work for a place that just got an injection of money in order to do the work with the managers and supervisors that are ready to lead in a program that is investing a lot in its employees and paying them the right wages. And so we're hoping we can be creative in putting all these factors together to get the FTEs that we need that will be provided with our new resources.
Okay, thanks. And then back to the allowable versus actual issue. So if these numbers are apples and oranges between 81 allowable and the 61 or so presumptive minimum based on actual, that implies that the actual emissions are higher than the allowable emissions. I mean, what's the experience of those two sets of numbers?
So the allowable emissions are higher. And so you'll see in the exhibit that Freeport provided that's in their demonstrative with the table, they have the allowables on the top and the actuals on the bottom. So for example, for particulate matter, the allowables are, I think, a little over 4,000 tons, and the actuals are actually a little over 500 tons, at least for one of their mines, as I recall correctly from the record. And so the idea is that they are apples and oranges, and that a lot of the states do use actuals. And so some of the numbers that you see, I mean, every state is different. And I should also add that every state has different ways of funding their program, which is another important thing to remember. So we've talked to states that have programs that are based on actuals, and then they have to run to the legislature and convince all the legislators that they need increases for their actuals, for example, if they're higher from year to year, or decreases. And so it is a turbulent process using actuals. That said, we had, the department had agreed many years ago to use allowables for certainty purposes in conversation with industry. And so that's kind of the genesis of the allowables versus actuals. For our program, like we said, we don't get a lot, we hardly get any funding from the general fund. And so we're not like the other states where we have to look at the actuals from year to year and then run to the legislature. We can have a steady increase, a steady increase or a steady decrease depending on what those allowables are. I think it also provides an opportunity perhaps for, lowering allowables as far as permitting. One of the things we can do is talk to folks, and if their actuals are so low, do their allowables have to be so high? Maybe that's a way to get emissions lower. So I think there's a lot of ways that we can use the current system of allowables in order to, make sure that, we're not overcharging, but it is the system that has been in place for quite a long time.
Okay, thanks. That's helpful. That's all I have.
Other board members, questions? Yes, Member Bitzer.
Just a couple of questions here. The FTE, 103 FTE, that's a big old chunk all at once. Well, first of all, let me back up a bit. Is the department or any division or bureau of the department considered an enterprise agency that is statutorily expected to be revenue neutral or revenue positive? When I was at regulation and licensing, the entire place was an enterprise agency: alcohol and gaming, construction industries, all the boards and commissions.
We're trying to follow an enterprise system where the folks that are served are the ones that are funding the program instead of going to the legislature and seeking new funds from year to year. And so that's the model that this proposal is trying to follow.
But currently, that's not statutorily expected. That's just a goal, policy goal, I guess.
Yes, that is correct.
Then I was at regulation and licensing, and then I was at human services. I had an enormous number of employees. And space was always a big challenge. If I brought 103 people on, where would I put them? You guys have empty office space at the moment, or are you going to?
We do not have any office space, but we do have a proposal out to acquire more office space. Right now, the office space we do have we have some office space in Santa Fe. However, we know that the markets, and this member Honker goes to your question, the markets for employees are not in Santa Fe at this time that we see. They're in Albuquerque and they're in Las Cruces. And so when we have folks apply, the office space that we do have available, it says Santa Fe. Well, Santa Fe, talk about cost of living, it's a lot. And so folks are moving towards more reasonable areas for cost of living purposes, which right now we are hearing are Albuquerque and Las Cruces. So we hear a lot of folks say, hey, do you have any positions open? And I say, what about Santa Fe? And they say, no, we don't want to go to Santa Fe. It's too expensive. So what we have been doing is working on acquiring new building space in Albuquerque first. And then we're going to acquire new building space in Las Cruces to kind of serve those needs and get the pools from the areas where people want to live and work in order to create the conditions that will set us up for acquiring the amazing employees that want to come work for us that are out there.
So that would be, you'd be renting then as opposed to owning? State wouldn't.
Currently, we are planning to rent, but we're hoping at some point that we can acquire a more campus type environment for our teams. And so we're still determining those details out, but for the short term purpose, we're going to be renting space near the locations that have the pools that people are wanting to work from.
And then you're regulating industries that are extraordinarily volatile, subject to global market and technology shifts. In my time paying attention, there's been bust and there's been boom. And an FTE is a very long-term commitment. What happens to all those new employees in this new office space if the markets shift and it's now cheaper to get copper and oil and gas or wherever from somewhere else, and you don't have a lot of activity to regulate? Do you have other things you could be doing with these people, or are they going to be, I've seen it happen in government, it's local level, the city of Albuquerque in particular, but some at the state, you get overstaffed. But once they've gone through their probationary period, you don't just get rid of them so easy. So is there some other part of the department that you can use them in, or are there other agencies that would be useful for these skill sets, or are you at risk of holding the bag, as it were?
That's a very good question. So into our projections into the future, we know that oil and gas and mining are industries that will be, lasting, at least in our projections. Well, for oil and gas particularly, throughout the Permian boom. I think I'm trying to recall off the top of my head the latest reports from the LFC, but it was, I think, 15 years. And so I think that at that point, if there's a need to, dare I say, decrease fees or, not have as many folks, or, I think there'll be some decisions into the future if there is not a need. Maybe my guess is that there will be, because of all of the work. I think that for air particularly, there is a lot of interest in greenhouse gas pollutants and how to bring those down. So I don't anticipate those particular folks, our air program going away, or a lot of, layoffs occurring. However, if there are changes that occur in the future, folks can always petition to have fees lowered, or changed, or modified. And, I think that that's always something that might happen. I know a lot of my colleagues have gone through boom and bust cycles in oil and gas, and there have been, there were layoffs during that time.
Yeah, I know y'all are averse. It sounds like y'all are averse to contracting the work out, but in instances where you're subject to a lot of volatility, it might help to leave some of that especially if you've got good contractors, good reliable contractors, so that you're not entirely putting all your eggs in the FTE basket. Anyway, that's just a comment at this point, but that's all I have. Thank you.
Vice Chair Trujillo, did I see your hand raised? Okay.
Yes,
Your
can you hear me
turn.
okay? All right, can you hear me all right?
Yes,
All
we
right.
can.
Thank you. Okay, I kind of bring up the train here. So I had some questions about comments I seen for administrative compliance costs, and just I was hoping maybe anybody on the panel can answer these questions, but if you could just walk me through so I have a better understanding of what that entails. Is that enforcement actions, like all enforcement actions, court costs, and how those are, how the NMED makes those determinations?
For administrative compliance costs, it is a misnomer in a way that it is compliance because it is mostly attuned to the enforcement actions, enforcement work that our Air Quality Bureau has to do in order to resolve instances of non-compliance. For example, we have staff that work hours and hours and hours on excess emissions reporting or different inspectors that go out into the field, and it turns out that what equipment was permitted is actually double or triple than what was permitted, right? So they have a permit for a certain piece of equipment, but really they have operations that far exceed what their permit requires them to do. And so we have been responding to complaints, particularly in the Permian, about different, from different constituents and folks that are concerned about smells and noises and other, possible issues down there. I think that for all of the work that we're spending on these enforcement cases and to develop them and to, sometimes we can negotiate them for settlement, sometimes we have to issue an administrative compliance order. They rarely get to administrative compliance orders since I've been here, but they occur, right? We try to bring the companies into compliance, but a lot of times we are spending too much time on all of the work that's needed to evaluate all of the technical data that we request and that we receive to determine what violations have occurred. And so our administrative compliance costs policy is an effort to ensure that those extra costs to the department are not borne by the compliant entities, but by the non-compliant entities based on the amount of hours that our staff is spending on all of these different cases. Right now, we have about 80 open cases, and I hesitate when we have, our inspectors go out and come back, because there's going to be likely more cases that are going to be added to that. And so rather than have a fee that rather than have a portion of the fee that we divide amongst all of the regulated entities for that work, our proposal here and what we've instituted at the department is to charge the non-compliant entity that fee as part of enforcement.
And how do you determine that non-compliant fee? Do you, like, how are those hours recorded? Do you assign a flat fee to those hours? Can you kind of give me a bigger picture of this?
Absolutely. So it is per hour based on the actions that the department had to take in order to proceed throughout the timeline of the enforcement action. And so there are certain administrative steps throughout that enforcement action. And we are keeping track of the time it takes for each of those actions. And that is, in a nutshell, how those costs are determined and applied. I should also add that the policy reason behind this also is that for purposes of and I think this was in one of the last comments or two that came in, when there is a violation of the Air Quality Control Act, we assess as the department a penalty on the non-compliant entity. That penalty does not go to the air quality program. That penalty amount goes straight to the general fund. And that's, in the big bucket. And so the idea is behind all of the work that our staff is doing on these enforcement cases. We are, happy to provide the penalty piece to the general fund with the idea that it is making New Mexicans, all of us whole, because there have been penalties. There has been a violation of the law that has, harmed the residents of New Mexico. And so that's where our penalty goes. But for our enforcement work that we do in order to obtain that penalty for the general fund, it is far more work than any fee in a way could ever get any. I mean, there's always a fee that can be obtained, but to correspond to that amount of hours. But really, we are choosing to not do that for purposes of these fees in order to not penalize the compliant entities for all of the work that we're doing for the non-compliant entities. Of course, it's our expectation that when we issue a permit, the person that is the permittee, the person receiving, knows the law, agrees to abide by the terms of the permit, and understand what those terms mean. But with our inspection, with our compliance rate that we've been calculating, there's clearly a lot of work to be done in that space.
Thank you. And I did see in exhibit, let me check, exhibit 14, there was some comments submitted about the administrative compliance costs, but no response was provided. And so I was curious if you had any additional comments on that as far as the being out of scope for the EIB to be able to consider this particular issue.
Yes. Thank you, Vice Chair Trujillo. We have submitted responses to the comments from Exhibit 14 as Exhibit 56. And that has
Okay,
additional
thank you.
information. Yes.
Thank you for that. And my last question on that is, do the administrative compliance costs also account for court costs? Are you pulling court costs into that as well? Or legal fees?
No. No.
Okay, that's all I have right now. Thank you.
Thank you.
Okay, Chair Sweeney has a few questions. We'll proceed with those and then we'll take a break.
Thank you so much, hearing officer. All right. The fellow board members had a great deal of discussion, so I just want to clarify and maybe wrap up some of the points that they were had questions about. Because we were discussing FTEs and workload, I just wanted to maybe ask, and it might be in the material, I was trying to look through it. What's the current number of positions within your bureau that are not filled right now?
I believe it's about 20.
Okay. And then to member Honker's point too is, so it would be 20, you would need 20 on top of the projected 103 positions that you would be bringing on or wanting to staff up to?
Yes.
Thank you. And then I know in one of the discussion points from member Ely and member Garcia, I just wanted, for my clarification, the average amount for each employee was about 103,000. And was that an estimate for salary plus benefits?
Yes, it's 130,000. And that is salary plus the benefits that the state provides for each employee.
Okay, thank you for that. And back to member Honker's questions about recruitment and retaining employees. I know that, industry probably offers much more. I was wondering if there was a consideration in terms of employee retention and recruitment, if there was also some analysis or projection of increase in that salary.
For for our state salaries,
Yeah, yes.
um, they do go up from time to time based on the costs, the natural costs of how the cost of everything goes up. But we believe that with 130,000, that would be sufficient for purposes of our FTE calculations. Of course, we do compete with industry for a lot of those jobs. And so, sometimes we're able to get folks. I know that some of my colleagues have had folks come over, but a lot of times everybody's going to have to make the decision for themselves about what job is right for them. And sometimes we don't have folks that we can't pay as much as industry does, but we have folks that, want to do something different with their careers or that sort of thing.
Thank you so much. And some other questions. So you talked about the systems needed and the antiquated state of some of the systems like Tempo, and understanding that a new system is going to be very is costly. So I think in terms of timing, I'm trying to understand in this proposed fee, will it enable the department to acquire those systems sooner than if these proposed fees don't get approved?
Yes, because we have to make decisions based on our budget. So if we don't have our proposal approved as presented, or if the board decides to do a lower amount, we're going to have to pick and choose which systems, technology-wise, we want to prioritize first. We'll have to do that to some extent anyway, because we're going to have to staff up. We're hoping contractors can help a lot with that, excuse me. And we have an RFP out right now, which is blanket air and climate RFP. Not that I'm standing here as a ad agency for that, but it's an acknowledgement that we are ready to run. And so I think that we'll have to make some more decisions, about what to pick and choose if we get a lesser amount, or if we don't get any amount at all, if the board rejects our proposal, we'll have to perhaps go with a more discounted model, or it might not have the features that we need. It might not be as transparent. We might not have like dashboard capabilities for transparency, or we'll have to figure out some ways to keep on keeping on with what we have. So we'll still do something, but it won't it might be more time consuming and perhaps not what we could get.
Thank you. Those are all the questions I have.
Thank you. Before we take a break, Mr. Prince, are you going to have redirect? For purposes of planning, yes.
I
Okay.
do not have.
Okay, thank you. Then we'll take a 10-minute recess and come back and start with the Mining Association witnesses at that time.
5:30.
Yeah.
Yeah, which is
Yeah,
nice to have.
yeah, that's plenty of. Half day.
At the end of all that commuting traffic.
It's like being in New Jersey or something.
Okay, we're back on the record. Before we proceed with presentation of evidence, the chair has indicated it might be advisable for the board to consider the motion to leave the record open at this time so we can get a decision on that and the parties have some guidance on where things are going to go from here. So with that, I will turn it over to Chair Sweeney. I had deferred that ruling on that motion to the board, so I'm going to turn it over to Chair Sweeney for purposes of taking up the motion.
Thank you so much, Mr. Hearing Officer. Could I, just for the board, maybe, was it legal counsel that made that request? Can you just share what the request was with the board again so we can all hear it?
Yes, Mr. Hearing Officer, Chair Sweeney. We had submitted for the Mining Association a motion at the procedural motions deadline, asking that the board hold the record open after the public hearing concludes in order for the parties to provide written closing arguments in particular. And it's helpful in our experience for us to have an opportunity to get the hearing transcript, have the record, and then provide a closing argument that, makes it clear where the arguments come from the record and that type of thing. That would mean that the board would need to conduct its deliberations and make a decision after those closing arguments come in. So that's certainly an implication for you all. I did note that the agenda did not identify specifically that board deliberations would take place today. So I don't know if that was intentional or not in terms of providing a signal in this, but I did know that was not on the written agenda that was approved for today's meeting. We did make that motion, and none of the other parties responded to that or objected to it. So right now, that motion is before you, and I think that's all I have to say.
Thank you so much. And with that last comment, I want to look to the other parties and see if you have any comment regarding what was just proposed. Yes, Enamidi?
Yes, thank you, Chair Sweeney, Hearing Officer Virtue. So on the motion, the department did initially indicate no position on the motion. However, at this time, we are opposed to the motion. We don't believe it is would be of much utility to the board to keep the matter open. And of course, a delay is very the Bureau is eager to have this matter decided without delay, and we think that would just simply delay the matter. And it's not I think the position of all the parties is going to be clear after today, and there's no legal, or at least from my perspective, it's not legally complicated matter. It's a rather straightforward petition, and a simple yay or nay by the board is all that it comes down to. So I don't know what would be gained by keeping by submitting final or final arguments in writing here, why the board would need that on this rather straightforward petition. So we are opposed to the keeping it open.
Before you put the mic down, I have one follow-up question to your comment. Is there any issues that NMED has on regarding maybe a deadline or delays? Like if we were to keep it open, is there something pressing in terms of deadline or timeline milestones that NMED is concerned about?
Well, other than, I mean, the state fiscal year is starting July 1, and that will impact, what the board decides here could have an impact on, will have an impact either way on the Bureau as it moves forward with this budgeting process and planning. Other than that, nothing specifically other than the urgency of the need by the Bureau to have this matter resolved either way, because it is, of course, a great concern to them.
Thank you for that. And Mr. Rose?
Yes, Chair Sweeney, we support the Mining Association's motion as we've submitted our support in writing. I'd point out that this is a contested hearing. In my experience, the board routinely allows for closing arguments and proposed reasons to be submitted in writing after the hearing, and as Mr. Molenberg explained, after the preparation of a transcript. I'd also point out that your rules allow you to request a hearing officer's report and then to make a decision based on that. And the fact that it's a contested hearing means that there's a likelihood of challenge, and it's really the board's counsel that has to prepare the order and the proposed reasons. And I assume that the board's counsel would be appreciative of the parties submitting proposed reasons to choose from, but it's your decision. I mean, any challenge would be on the basis not just of the final rule, but also on the proposed, on the reasons adopted by the board. One additional point I'd point out, and it was raised in relation to my objection to the board's or to the department's Exhibit 15, there was a question about whether the department was looking at additional support from either ERG or for someone to respond to and support the assumptions in the ERG report. And my understanding is that hasn't yet been decided. So as to your ability to make a decision today, I'd agree with Mr. Molenberg as I read the agenda of this meeting, that I think you'd be in violation of the Open Meetings Act if you actually did try to rule today and make a final decision. So again, we support and concur in the Mining Association's motion. Thank you.
Thank you, Mr. Rose. Yes.
Yes, Mr. Hearing Officer, Madam Chair, just briefly, I would note that we filed our motion by the deadline for procedural motions. There wasn't a separate deadline for parties to file a response. As Mr. Prinz indicated, they initially indicated they had no position on the motion. They did not file a response. So from our perspective, they've waived the right to now respond to this motion per the terms of the pre-hearing order. Other than that, I would disagree with Mr. Prinz's characterization that there are not legal issues involved here. We think there are significant legal issues. And I would also agree with Mr. Rose's comments. Thank you.
Thank you. Thank you all for that input. And so I look to our board members and see if there's any motion, and so that we can open up discussion on this matter. Yes, Member Garcia.
Yes, thank you, Chair Sweeney. I would, I think it's been the practice of this board to normally allow the record to remain open when requested. So at this point, I would like to make a motion to grant the motion to have the record remain open. Did we say a time frame?
We did not say a time frame, and I'm look to our legal counsel.
Thank you, Chair Sweeney. So we can leave the record open. Usually it seems to be about 30 days, and that also allows the hearing officer an opportunity to draft a report if he wants to do so. And then after the hearing is closed, the record is closed, or after the submission of the report, you will have 60 days to make a decision. And I do want to just jump back really quickly and clarify that of course, yes. Can you hear me now? I do just want to clarify that your agenda does allow you to make a decision and vote and take formal action today or tomorrow if you want to do so. There's no OMA violation there. That being said, yes, you can leave the record open, and I would ask the parties if they have a specific request for a time frame, I think. And then also Mr. Virtue, if you folks want to have a hearing officer's report to ensure that he has ample time to prepare.
So point of order. I know you began your motion, so I want to make sure that we finish out what you wanted to say, Member Garcia.
Thank you, Chair Sweeney. So I would amend my motion and put forth a motion to grant the motion for an extension for closing arguments of 30 days from today.
I would second that.
Thank you, Member Garcia. We have a second by Member Bitzer. With that, I want to see if the members have any points of discussion, questions.
So the timing on the deliberation would then be August sometime at our August meeting, or a set date for deliberation.
Yes, I think that would also be dependent if we want a hearing officer's report as well. Am I correct on that?
I'm available after August 18th.
Thank you, Member Ely. Is there, in terms of timing, we'll make sure that we take that into consideration. Any other members have any comments, questions? I'm looking up at the board. Yes, Member Honker.
Yeah, I'm supportive of the notion of leaving the hearing open. It does seem like we as board members had a lot of questions for NMED witnesses. We may as well with the other parties' witnesses. It seems like we gained some additional information that we wouldn't have necessarily been able to get from the exhibits or interpretation off of exhibits and stuff like that. So it seems like a fair thing to do, to leave the record open so that the discussion we have had, the transcript of the hearing, and all of that could be adequately digested and reacted to.
Thank you, Member Honker. Fellow board members on the platform, do you have any comments? All right, we're back on. All right, sorry, platform, we lost you there for about 10 seconds. And just looking back at the platform, Vice Chair Trujillo or Member Bitzer, do you have any comments or questions?
No, I don't.
Thank you.
Nope, I'm good.
Okay, well, with that, we have a motion on the floor and a second. Is there any, I think we're good with comments. Ms. Jones, would you please do a roll call vote on the motion?
Yes, I will. Member Bitzer, how do you vote?
Vote yes?
And Member Ely?
Yes.
Member Garcia?
Yes.
Member Honker?
Yes.
Vice Chair Trujillo?
Yes.
Thank you. And Chair Sweeney?
Yes.
The motion carries.
Thank you, Ms. Jones. With that, I want to also see if we want to discuss a hearing officer's report. And I will look to my fellow board members if you have any, if anyone wants to make a motion on that.
I move that we request hearing officer Virtue to prepare a report for the board within a reasonable timeframe. What would that be?
I like that.
I'll second that.
I second it.
Thank you, Member Ely and Vice Chair Trujillo, Member Ely for your motion and Vice Chair for your second. With that, I want to see if we have any discussion. If not, I think we can go right to a roll call vote. Ms. Jones, would you please do a roll call vote?
I will. Member Bitzer, your vote?
Vote yes?
And Member Ely?
Yes.
Member Honker?
Yes.
Member Garcia?
Yes.
Vice Chair Trujillo?
Yes.
Chair Sweeney?
Yes.
Motion passes.
Thank you. I think those are the administrative items. Is there anything else, Member Ely?
The question about another NMED witness.
Yes, to NMED Council, Mr. Prince, or is there still a request? I know there was some discussion of whether we were going to have another witness.
Yes, Chair Sweeney, Chair, or Hearing Officer Virtue. On the matter of the Exhibit 15, we can make that witness available via, I believe she's down in Las Cruces, so she could appear virtually. Time being by the end of the day, or it might have to be tomorrow.
Is there a necessity to have that? I know it's regarding Exhibit 15.
Right. I mean, I guess I wasn't sure, even if that, if it was necessary to have her appear and provide any information about the exhibit itself. The exhibit, I mean, whatever I say about the exhibit is not evidence, or, but I can't tell you about the exhibit, about the information that that was used to draft the memo. It did come from the department itself. It was all information, that was provided by the department. That was basically the same information that was contained in all the testimony that was presented by the department. It was compiled by the ERG, the contractor. It didn't really provide new testimonial evidence or testimony. If you do look at the memo, it doesn't do that. It's all information that's been already covered, and all the witnesses have been asked questions about all their testimony, obviously. So I don't think, obviously it's my position that I don't know what would be gained by having her come in, but I do understand the objection by my opposing counsel, and that they might obviously feel differently. But I guess that's our position, that it doesn't provide, it's not testimonial evidence that would, or technical testimony rather, I guess the word I'm looking for.
Um, But it's up to a hearing officer to decide.
Thank you, Mr. Prince. And Mr. Hearing Officer, if you have any input.
Well, the exhibit was admitted into the record with the caveat noted in the objection that counsel for the Independent Petroleum Association made. So it is part of the record. And it, as I see it at this point, it's up to the board in terms of how much weight it wants to give that exhibit. So it was offered, it was objected to, and it was admitted, and it's in the record. And I believe the board can proceed with the record, as it stands. It sounds like the department is saying that's acceptable to them. So I think we're in a position where the board can proceed with the record as is.
Thank you, Mr. Hearing Officer. Members, I don't know if we have to take a motion or, but up to you all.
I don't feel like I have to make a motion. I just want to say that, the objection came up during my line of questioning, and I don't feel a strong need to have the ERG witness in attendance, in part because I will weigh the evidence based on, that person not being available to answer those detailed questions as noted by Hearing Officer Virtue.
Thank you, Member Ely. And I'm just making sure our board members on the platform don't have any other comments on this topic. And if not, I will turn the proceedings back over to our hearing officer, Mr. Virtue.
Thank you, Madam Chair. We will now go to presentation of the Mining Association's evidence.
Thank you, Mr. Hearing Officer. If it's okay with you, I believe the three witnesses for the Mining Association could be sworn together.
Okay, let's have each of you identify yourselves and spell your names, and then we'll have you sworn in.
Hello, my name is Matthew Thompson, MATTHEWTHOMPSON.
I'm Sherry Bird-Kested. Sorry, he said I need to spell it.
This for the benefit of the court reporter.
Sherry, SHERRY, Burt, BURT, hyphen, KESTED. Sorry, long one.
And I am Michael Sonnenberg, MICHAELSONENBERG.
Thank you. So, Mr. Hearing Officer, I'll go ahead and we'll deal with each witness one by one and then make them available for questioning as a panel. Sorry, sometimes I get too close and it screeches. So
it's a delicate operation.
Yes. Thank you, Madam Hearing Officer, or Mr. Hearing Officer. We will present the witnesses one by one and then make them available for questioning as a panel.
Okay, that's fine. Just to let folks know, we do have a public comment session scheduled for 5 o'clock, which is about a half an hour from now. So I will interrupt at that point to allow for public comment. I do have one person who wants to make a comment. And then, assuming that's the only person, we'll go back to testimony until 5:30.
Thank you, Mr. Hearing Officer. Let me start with Mr. Thompson, you've stated your name. Could you give us your position and the general purpose of your testimony?
Yes, my name is Matthew Thompson. I am the incoming executive director of the New Mexico Mining Association, and I am here to represent the interests of the mining industry in New Mexico.
Thank you. And Mr. Thompson, your testimony really isn't technical so much as it's an introduction to the association and its membership. Is that right?
Yes, that is correct. The Mining Association members include companies with active mining operations who hold air quality permits issued by the New Mexico Environment Department Air Quality Bureau and who pay operating permit emission fees under 20.2.71 MAC and construction permit fees under 20.2.75 in MAC.
Mr. Thompson, if I could interrupt you for a minute, I skipped a step here, and that is you did provide a written direct testimony for this proceeding as that's identified as exhibit NMMA 4. Is that right?
That is correct.
And you were proceeding to discuss your written testimony. Is that right?
That is correct.
And do you adopt your written testimony as your testimony for purposes of this proceeding?
Yes, I do.
Fair enough. Then go ahead and provide your summary of the testimony.
Thank you very much. Hearing Officer Virtue, Chair Suena, members, the New Mexico Mining Association include about 100 members across the state that are active mining operations who have air quality permits. There appear to be approximately 145 facilities in New Mexico who hold Title V operating permits. And according to the same source data from the Environment Department, 3 of those are NMMA members that hold 4 Title V permits. Those are Freeport McMoran, Chino and Tyrone Mine, and near Silver City, and Intrepid Potash and Mosaic Potash mines near Carlsbad. So just to touch very briefly on some of the social and economic values of the New Mexico Mining Association and industry, many metals that are mined by NMMA are now recognized as critical for electrification and renewable energy, including copper, lithium, and rare earth minerals. And many organizations have opined that without increased production, these minerals and metals, government climate change goals may not be able to be met. According to the latest annual report from the Mining and Minerals Division of the Energy, Minerals, and Natural Resources Department in 2022, New Mexico ranked first nationally in potash production, 6th in copper production, and 13th in coal production. The total value of mineral production was approximately $1.9 billion, with direct and contract employment of over 4,200 employees, an annual payroll of over $285 million. Very briefly, some of our concerns with the Air Quality Bureau's proposed fee increase will be addressed more specifically by technical testimony of Sherry Burt Kested, which is being filed concurrently with my testimony. As you know, mining is a capital-intensive industry, and several years of mineral exploration, planning, permitting, and construction are required to develop a world-scale mining project. The magnitude of the proposed fee increases would not only unduly burden New Mexico's existing miners, but could discourage mineral exploration and production in New Mexico needed to meet the needs of consumers and government climate change goals. That concludes the summary of my testimony, and due to the lack of information in the petition to support the proposed rule, as discussed in detail in Ms. Burt Kested's testimony, I may have additional rebuttal testimony once I've had the opportunity to review the direct testimony. Thank you.
Thank you, Mr. Thompson. Let me move to Ms. Burt Kested. Could you please state your name once again for the record?
Sure. Can you hear me okay on the WebEx? Sherry Burt Kested.
Thank you. And did you provide a copy of your resume as NMMA Exhibit 3?
Yes, sir, I did.
Could you give us a brief summary of your education, experience, and qualification as it relates to this hearing?
Sure. I'm currently the environmental manager at our Freeport McMoran, Chino, and Tyrone mines in the southwest corner of the state. I've been working in environmental compliance, including air quality compliance, for 20 years now. It's hard to believe, 20 years. I'm also a member of the New Mexico Mining Association Environment Committee.
Thank you. And Ms. Burt Kested, did you provide a direct written testimony for this hearing as in MMA Exhibit 2?
Yes, sir.
And did you also provide written rebuttal testimony identified as exhibit in MMA 12?
Yes, sir.
And do you adopt those written testimonies as your testimony for this hearing?
Yes, sir.
Thank you. Would you, do you have any corrections to your written testimonies to offer at this time?
No, I do not.
Okay, thank you. Would you proceed to give the board a summary of your written direct testimony? And I believe you're intending to consolidate that with your written rebuttal testimony. Is that right?
That's correct.
Thank you. Please proceed.
Okay, Mr. Hearing Officer, members of the board, everybody here, thank you for the opportunity. I will be providing a summary of both direct and rebuttal at the same time. And I do have a presentation that I'll pull up. Hopefully it works. Share. Is that working? Stop. I was just trying to figure out how to make it bigger. There we go. All right. So the Air Quality Bureau testimony does not provide sufficient information to industry stakeholders in order for us or the Environmental Improvement Board to evaluate whether the Bureau's proposed increases are reasonable. Both industry stakeholders and the board need additional information to assess the reasonableness of the proposed fee increase. And I know we've talked about a lot of this already. It's been a long day. I'll try not to repeat what we've already talked about. But some of the things that we would need to know to understand if this is a reasonable proposal are the projected future program expenditures for each of the two specific programs funded by the fees. We've gotten a long list of needs, and there were more provided today, but there was no cost estimates provided for those needs for the program. Specific justification for any increase in the per ton fee rate under the Title V program, showing that any increases are needed to adequately fund specifically the Title V program. All parties appear to agree that the fees collected under the Title V program can only be used for the Title V program. So unlike other recent rulemakings, we talked about this as well, the Air Quality Bureau did not provide stakeholders with advance notice of the proposed changes. We did not find out about the proposed fee increases until the Bureau filed its petition on March 7th. There was only one very brief public meeting that I did attend on March 20th. And it seems like 3 months have gone by really fast. The available information through both the New Mexico Mining Association's testimony and New Mexico Environment Department's testimony does not support either the urgency to rush to increase fees or that fee revenue is falling behind expenditures drawn from the fee funds. And I'll point you to slide 2. Hopefully this is sharing. You can see on this PowerPoint that the Air Quality Bureau currently has a fund balance of approximately $6 million in the Title V fund and $19 million in the construction permit fund. This is based on 2023 expenses. That's enough money to continue to run the program based on past expenditures for 2 to 3 years. And it also appears these funds are immediately available for some of the agency's critical needs. An important note here is also that the balance in the Title V fund, we got this from a report that provided that balance as of March 31. That was before this year's Title V fees were due June 1. So we assume, again, based on past expenditures, that this fund balance will grow even more. You can see in the next couple of slides that the Air Quality Bureau revenues in both the Title V and construction permit funds have exceeded expenditures drawn from NMED from those funds for the past 3 years. So we've talked about some of these numbers. This just provides a nice chart. You can see in blue is the revenue in Title V fees for each year. In orange are the expenses for the Title V program, and net revenue is here in green. This is the Title V program, and then this slide shows Part 75, and again showing net revenue for each of the last 3 years. NMED's focus regarding the need for increased fees during the public meeting that we had, the subsequent meetings that we had with the agency, and their written testimony has all revolved around the oil and gas industry. These very high-level needs that have been expressed in the testimony included future permitting and compliance with New Mexico's new Part 50 regulation, which is specific to oil and gas. The potential that the eastern part of the state will be designated non-attainment in the future. Increase in oil and gas permits, the vast majority of which appear to be general construction permits. And the increase in construction or NSR permitting, including modeling. None of these potential reasons for adjusting the fee rules pertains to the mining industry. However, the impact of the increase in fees for mining is substantial. As shown in my written testimony, the increase in fees will result in a total annual fee in the Title V program of nearly $1 million for the 2 copper mines operated by Freeport-McMoRan. $1 million per year. This proposal is inequitable and completely unfair to the mining industry and substantially higher than the fees paid by similar mines in Arizona. Here I have a slide that shows the fees under the current proposal that would be paid by our Tyrone mine and our Chino mine, located here in New Mexico, as compared to our Sierrita, Baghdad, and Morenci mines in Arizona. Sierrita and Baghdad are very similar in size to Chino. Morenci is probably 5 times the size of Chino. It's a massive mine. And I will note as well, there was some discussion about this earlier. Arizona fees are based on actual emissions, and they also do not have allowable limits for what we call fugitive emissions. That's also something unique to New Mexico, that we have allowable emissions limits for fugitive emissions, which are emissions from things like haul truck dust, stockpiles, wind erosion, things that are not controlled by a stack. Most other states do not have allowable emissions for fugitive emissions, especially for minor NSR sources like us. Also, the discussion regarding permitting and compliance for the oil and gas industry is primarily related to the construction permit program, not Title V. NMED's testimony shows that the vast majority of the increase in permits is general construction permits and construction permitting, not Title V. However, the increase in Title V emissions fees is significant. NMED has not made the case that the Title V emissions fees are not sufficient to run the Title V program or to explain what additional staffing and funding might be needed for the Title V program separate and apart from the construction program. The only justifications provided by the Bureau for the proposed increase in Title V operating fees are that the current fees are below EPA's presumptive minimum and that the fee rules have not been updated in several years. And I know we've already discussed the presumptive minimum issues, so I won't get into that anymore. So consequently, I think we all now agree the EPA presumptive per ton rate based on actual emissions cannot be compared directly to the Part 71 per ton rate based on allowable emissions. So again, revenues have exceeded expenses for the past 3 years, and NMED has not provided the board with any testimony indicating that there are deficiencies in NMED's current Title V program that need to be addressed through additional funding. Lastly, on slide 6, I show the current fees paid by our New Mexico mines compared to what the fee would be under the current proposal and with and without particulate. And the reason I highlight this, there's a couple reasons. Let me see if I can hide this. I collapse that view. I still can't really see what I'm doing. Oh, I can drag it away. Here we go. So you can see here, Chino's allowable emissions are quite high. This is to allow us operational flexibility. It's been mentioned that commodity prices are high right now. Thank goodness, because cost of production is also incredibly high. And those commodity prices move up and down frequently. Most recently, just a couple of years ago, we had a crash in copper price. And so we have to be able to react quickly to that change in commodity prices. So we intentionally set our allowable emissions very high to give us that flexibility. So we show our allowable emissions here, what our 2023 Title V fee was. And I do want to point out, we have been paying fees for the last 7 years and clarify that it was only particulate emissions that we were not being invoiced for because the change in the rules several years ago to eliminate TSP. NMED added particulate matter 10 and 2.5 to the definition of fee pollutant as part of this proposal without an explanation as to why they were doing that or any explanation as to what the revenue would be generated as a result of adding back particulate matter. After what we've learned today, I think it's pretty clear that they did not include the increased revenue from particulate matter in their projections of how much money they wanted to generate in the future. So here we also show what the 2023 fees would be if PM10 had been added. And we also show what happens under the proposed rule, which is one, increasing the per ton fee to $81 per ton, and also adding particulate matter. That will raise our fees from $66,000 per year to over $500,000 per year. Per Tyrone, that increase will go from currently $132,000 per year to $455 million per year. So between the two mines, that's $1 million per year, or 1/8 of what the Bureau has said they want to generate for Title V fees. Again, we think this is inequitable compared to 140 odd Title V sources in the state. Oops. I think this is all that I wanted to cover here on this slide. Lastly, I wanted to point out that the Part 71 program is not currently subject to periodic review by this board. However, the construction permit program is subject to annual review. The Bureau has included in this proposal to eliminate that requirement. NMMA is very concerned about the proposal for a significant increase in fees, while at the same time providing less oversight for this board to see what those fees are being used for. That concludes my summary. Should I hand off to Mr. Sonnenberg?
Well, thank you, Ms. Bertkested. I had just a couple of things to follow up on. I think one minor thing is I think you may have misspoke, just so the record is clear. I think you mentioned the Tyrone fee being $455 million.
Oh, wow, that would be rough. Sorry, $455,000.
Thank you. And Ms. Bertkested, in your testimony, did you provide some information to give the board some perspective on the likely workload, so to speak, of the department as it relates to the Title V permit program?
Yes, I did. Based on my experience managing air permits in the past, and I sat down with my 2 employees that manage our current Title V and NSR permits at Chino and Tyrone, and we calculated that we spend approximately 300 hours per year for putting together applications, reviewing information, gathering all of the monitoring and record keeping that goes into our semi-annual reports, preparing those semi-annual reports, Title V compliance reports, getting all of that uploaded to the wonderful NMED software. That all comes to about 300 hours per year per site.
Thank you, Ms. Bertkested. I believe you've been here for the all of the hearing today. Is that right?
That's correct.
Have you heard anything else today that you might want to specifically comment on at this time?
There was some new information provided today, and I think the big one was that before today, we had not heard how much revenue the Bureau wanted to generate from the Title V fees. And today we heard that's $8 million. And I already mentioned that based on that, Chino and Tyrone would be paying for 1/8 of that total revenue to be generated.
Thank you, Ms. Bertkested. I appreciate your testimony. Mr. Hearing Officer, we have a little under 5 minutes left. We could get started with Mr. Sonnenberg now. I know we have a 5 o'clock time. My guess is we might not get finished with him. So is it your pleasure that we go ahead and proceed and get started?
Yeah. I'm looking at my watch here. It actually is 5 o'clock, or it's approaching 5 o'clock. 5 o'clock by 2 watches in the room, mine and the chairs. So we're gonna go by that. So we'll recess in place here. The hearing, and I'm going to call upon call for public comment. I know we have one person on the WebEx platform who wants to make a public comment. So we'll start with her. Her name is Camilla Peeblebaum.
Pretty
Would you
close.
please,
Yes.
at least
Sorry,
that's the name I have. You can,
Sorry.
ma'am, if you could just identify yourself and spell your name, and
course.
you'll have 3 minutes to present your testimony. We'll swear
Great.
you in first.
Sounds good. Name first or swearing in first?
Name first, please.
Okay. Yes, I'm Camilla Feibelman, and that's Camilla. And the last name is Feibelman, F as in Frank, E-I, B as in boy, E-L-M-A-N. And I'm the director of the Rio Grande chapter of the Sierra Club.
Okay, we'll have you sworn in and then you can proceed. I can do it. Ms. Feebleman, do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Okay.
Great. Well, first, thank you so much to the board and all of the interveners for taking on this important issue. You'll note that my organization, along with Environmental Defense Fund, Conservation Voters New Mexico, Earthworks, Health Action New Mexico, Moms Clean Air Force, National Parks Conservation Association, New Mexico Interfaith Power and Light, New Mexico Sportsmen, Progress Now, the Western Environmental Law Center, and Rio Grande Indivisible submitted a comment in support of the increased fees. We want to flag that as the rulemaking involves revisions to Title V operating permits and construction permit fees, that these haven't been updated in more than 2 decades, during which time New Mexico has grown to the #2 oil producer in the US and witnessed increases in health harming ozone pollution in both of the state's major oil and gas producing basins. Oil and gas permits account for 80% of the permits issued by NMED, and as the Bureau states in its petition, with the increase in permitted facilities largely due to oil and gas production, the Bureau's compliance effort to ensure all of the permitted facilities are meeting state and federal air quality requirements to prevent non-attainment status designations are inadequate. Increasing these fees will help NMED better meet increased permitting demands and the growing need for industry oversight, as well as to help ensure that industry bears the cost of this oversight. Oil and gas sector is the largest human caused source of volatile organic compounds nationally, as well as in New Mexico, and a significant source of hazardous air pollution, both of which cause negative and sometimes irreversible health consequences for communities living near oil and gas activities. Increasing permit fees will help NMED ensure proper oversight of the oil and gas industry, as well as cutting air pollution, which will have vital benefits for our climate and our communities. So thank you again, and indeed, please do support these fee increases. Thank you.
Thank you, Ms. Feebleman. Is there anyone else on the WebEx feed who would like to make a public comment or testimony at this time? So,
Yeah, yes. This is State Representative Catherine Brown. I hope you see my hand is raised.
I can't see you, Representative Brown. Please spell your name and we'll swear you in.
Yes, sir. State Representative Catherine Brown, CathrynnBrown.
Okay. And do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Okay. We're allowing 3 minutes for public comment. Please proceed.
Okay, I do have my camera on, and I guess I'm disembodied through the technology here, but so I'll just make a few oral comments then. So members of the board, I am a state legislator. I'm in my 14th year in the legislature, and I'd like to give you a legislator's perspective on the subject of today's hearing. It is the province of the state legislature to decide the budget for state government, including the agencies. We do decide the number of FTEs. We also set policies, and of course, the governor, after the legislature has spoken, has a say in the matter as well. But we have a duty in the House of Representatives to start the budget, and I think the process is fairly well understood. We have an agency request, a recommendation. We also have, on the other hand, a recommendation from the Legislative Finance Committee. The HAFC looks at all of that information and makes a recommendation of its own. And then that goes to the House of Representatives for consideration. And if it passes, it goes to the Senate Finance Committee and basically to the Senate and so forth. So the process is vital. And what it does do is prevent vetting. And I think we would have a lot of problems if we allowed agencies to basically set their budgets unilaterally. I believe that NMED's proposal is out of order, and that the Bureau is asking the EIB to act ultra vires. New Mexico's Environment Department has received generous consecutive budget increases, and yet it still struggles to fill vacancies. And these are funded vacancies, and it's a chronic issue. So there is already money in the department's budget and the Bureau's use of it to do the permitting, and I would hope to do it in a timely fashion. We've heard that NMED wants to add 103 to 110 new FTEs. But FTEs are set through the budget process in the legislature, and individual agencies do not have the latitude to determine that. So this is, I think, a violation of our established process. It's my opinion, members, that the subject of escalating fees can wait a few months until the legislature convenes in January of 2025. And I cannot stress enough the importance of following the budget process. We need to hear from the Legislative Finance Committee for one thing. It's a professional year-round staff that vets these types of things, and we do need their input. So members of the board, I'll just finish up by saying that an increase in fees of this magnitude is shocking, especially the one proposing to go from $5,100 to $25,500 for a permit. It is not justified. The department has plenty of money on hand. Again, it's exorbitant in the extreme. And again, it's the province of the legislature to set the budget. Ultimately, I think this is a venue issue. The venue should be the state legislature, not a board. So I urge the EIB to take no action or reject NMED's proposal to replace NMAC 20.2.71 and 20.2.75. And then final comment is that I have looked at NMED's public involvement plan, and I believe that stakeholder consultation was woefully insufficient in this case, and there needs to be more time for public comment. So thank you so much for hearing me out today.
Thank you, Representative Brown. I believe there's a Joan Brown who would like to make a comment also.
Yes.
Would you please state your name and spell your name, and then we'll swear you in.
Yes, my name is Joan Brown, JoanBrown.
Okay, and do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes.
Okay, well, please proceed.
Thank you. Thank you so much, board, for looking at this important issue and also for entertaining public comment. I am Joan Brown. I'm a Franciscan sister, and I'm the executive director of New Mexico Interfaith Power and Light. We work with faith communities, people of faith and conscience all over the state. And we often hear from our members that, you know, our traditions say we need to be fair in the world and do our due diligence, all of us, to care for our communities and our sacred lands and water. And so we support this increase in NMD's operating permit, emission fees, construction permit fees. They have not been increased in over 20 years. Many things have increased. Everything has increased dramatically in 20 years in terms of cost. And the ordinary people, taxpayers of New Mexico, need to be treated fairly, just as everyone else thinks they should be treated fairly in terms of costs and fees. So we're very much in support of this, and thank you for this important hearing.
Thank you, Ms. Brown. Is there anyone else on the platform who would like to make a public comment? Seeing none, and I'm informed that no one else has signed up on with the host. So we'll turn to the hearing room. Is there anyone in the hearing room who wishes to make a public comment at this time? Okay, seeing none, we'll return to the Mining Association testimony.
Thank you, Mr. Hearing Officer. At this time, the Mining Association calls Michael Sonnenberg. Would you please state your name?
Michael Sonnenberg.
And Mr. Sonnenberg, did you provide a resume indicating your education, credentials, and experience for this hearing?
Yes, I did.
And that's identified as Exhibit NMMA 13. Is that correct?
That is correct.
Or I'm sorry. Actually, I read the wrong one too. NMMA 14.
That is correct.
Did you provide written rebuttal testimony for this proceeding identified as Exhibit NMMA 13?
Yes, I did.
And do you adopt that written testimony as your testimony for this proceeding?
I do.
Do you have any corrections to that testimony at this time?
No, I do not.
Thank you, Mr. Sonnenberg. Would you proceed to provide the board with a summary of your written rebuttal testimony?
Yes, I will. And I'm going to try very hard to not repeat some of the same things that we've heard over and over again today. I want to start off by saying in my testimony, that NMMA supports adequate staffing and funding for the air quality program. That's not why we're here today. We're here because NMED's testimony is very general in nature, and it does not describe the reasons for the fee increase. It is not specific enough for NMMA to determine if additional funding is needed. And some of the things cited by NMED, such as federal regulations, in my experience, do not require a lot of extra effort on the part of NMED to enforce. They are federal regulations that the state can be delegated to enforce. And usually that means reviewing extra reports or adding onto an inspection or a permit, but it's not a massive increase. The only thing that they did cite that requires, I think, more than that level of effort is, I'll say, so they cited, like, example, NSPS Quad J, Quad I, Quad O. Those are, as I described, federal regulations. Quad OC is promulgated under a separate section of the Clean Air Act. That's 111D, and that does require a little bit of additional effort on the part of the state to develop those regulations. In addition, non-attainment does not add to the permitting burden significantly. It actually stops permitting in an area. Okay. All right. So moving on, there's no specific information to evaluate the increase to $81 per ton for the Title V fees. There's not really specific information regarding the modeling fee increase, as the board has noted. I will note, because it did come up, it was not in the initial testimony. It was not part of the exhibits, but the EPA letter that came in later. It's my impression from reading it that it does not support the fee increase. What EPA says is, if you read that letter carefully, is they outline what the fees can be spent on. And they say, and then they continue on to say that New Mexico Environment Department has conducted an analysis of the program and found it inadequate. It does not say that EPA has done their own analysis. EPA did do their own analysis in 2019, and that was included as one of our exhibits, was EPA's audit of the program. And EPA at that time in 2019 found that the program was adequately funded. With that, I'll conclude in my testimony. NMMA is interested in engaging in a stakeholder process to raise fees. There may be things that we're not aware of, but given the information in the testimony today, we do not see a reason for a fee increase.
Thank you, Mr. Sonnenberg. You've sat through the hearing that's taken place all day here. Is that right?
Yes, I have.
Have you heard anything today new that would cause you to comment on it?
No.
Okay, thank you. Mr. Hearing Officer, that concludes the presentation of the Mining Association witnesses and their summary of their written rebuttal testimony. As I understand it, their testimony, along with all of the other exhibits, have already been admitted as evidence. So I believe we're ready to make the witnesses available for questioning.
Okay, we'll go to cross-examination. Mr. Rose, you're next. Okay. Mr. Prince. Yeah, we have an extra mic up here.
Yes, good afternoon. I'll start with Ms. Burkested. Questions for you. If I could bring your attention to your demonstrative exhibit. This time. It was the panel or slide for it. Okay. On your demonstrative exhibit, slide 4, which you had up on the screen there, you compare the cost for the comparison of annual Title V or Title V rather operating fees for New Mexico mines versus other large U.S. mines. You know which slide I'm referring to?
Yes, yes, I do. Would you like me to bring it up on this?
Sure, if you could.
I think I still can.
Just so everyone can, yeah, I know you and I know it. So the slide
It's
before, I think
It's
is
not
slide.
letting me change for some reason. Oh, there we go.
There.
There it is.
Okay, yes, sorry, thank you. So on this slide, you compare the Tyrone and Chino mines to the Sierrita, Baghdad, and I'm maybe mispronouncing it, but Morenci mines, right? Correct?
Correct.
And those 3 mines are in the state of Arizona.
Yes, sir.
And those 3 mines are operated by Freeport-McMoRan.
Yes, sir.
Along with, there's 2 other copper mines, I think, in Arizona that Freeport McMoran operates. Is that correct? Or just these three?
We have a mine in Smelter, Miami, and no?
Well, that mine isn't operating. We have a mine in Safford as well that is operating.
Okay. So those, is that why, I mean, you could have compared, well, let me ask you this, you're in the mining industry. And so are you familiar with the Bingham Canyon copper mine in Utah?
I am.
I think that's the second largest open pit copper mine in the United States. Is that correct?
Oh, we argue back and forth.
Right, okay. But you chose to focus on Arizona as a comparison.
We did not have a lot of time after getting information about this fee proposal. We did reach out and we did actually get that answer, but it was after we submitted our testimony. I don't have the number in front of me, but we do have it and we could supply it by tomorrow unless Mike
No,
has
I it.
it.
have it. It's $70,000.
That would be the state of Utah's fees?
That would be the state of Utah's fees for the Bingham Canyon mine and concentrator.
Okay.
And it came in too late to introduce as an exhibit, but we have it.
Okay, so I guess I'll have to take your word for that.
We can share the document.
You know, well, talking about Arizona's Title V program now, do you know if Arizona's Title V program is adequately, you know, meeting all its needs of its Title V or the fees rather sufficient to provide all of the needs for the Arizona's Title V program?
I'm going to defer to Mike Sonnenberg on this one.
Yeah, I want to address that. So Arizona has recently been audited by EPA, the same audit that New Mexico went through, and EPA did find the fee to be sufficient to fund the program. I will say that Arizona's fee is set up differently than New Mexico. So mines in Arizona, they pay a flat fee. So they pay about $20,000 each as just an administrative fee, no matter what size the copper mine is. And that is based on the cost of reviewing the reports, doing inspections, things like that. In addition to that, for the largest mines, they pay an additional fee of, I think it's around $50 per ton. But the minor source mines do not pay that per ton fee. And so Safford mine pays the same fee as Sarita mine for that reason, is because they are just paying the administrative fee and not the per ton fee.
And on the next slide, if I could bring your attention to the next slide that you have, that one there. So on the top, you have Chino allowable emissions, PM10 for 4,681.27, for example, correct?
Yes, sir.
And then a total emissions of 6,416.55. Now, isn't that, I think as your testimony, or you indicated in your testimony, that because commodity prices can fluctuate, you're never quite sure what the needs are going to be in the market, that it's perhaps a business decision to set high allowable emissions to ensure that you have some leeway to, if you need to go high, you can go high. Is that correct?
Yes, we need to make sure that we have the flexibility to make changes frequently. We've made changes even just in the last couple of years that resulted in halving our mining rate. And then next year we project we'll double that mining rate. So we need that flexibility to move quickly. And a significant permit revision takes minimum 6 months. So we need the flexibility in our permit to be able to make those mine plan changes quickly.
So, but then those numbers, the allowable emission numbers, those are set by you put those numbers forward, correct?
We apply for them, correct?
So you could go lower on those allowable emissions, but that's just a business decision that your business decides to make. Correct?
Yes, we could. We could go through a significant permit revision and request lower allowable emissions. That would reduce our flexibility in our operating plan.
Okay, and it would also reduce your fee, correct?
It would, at the cost of reduction in operational flexibility.
Sure. That's sort of some of the fun of being in a regulated industry, correct?
Yeah.
Put it one way. I'd also like to draw your attention there to, I guess, the second chart there. You have actual emissions. And so Chino's 23 actual emissions, 558.1 of particulate matter. So I mean, isn't just in general, open pit mining, is it fair to say that the largest pollutant coming from open pit mining is particulate matter, just because of the nature of the business?
Yes. And again, here in New Mexico, we have allowable emissions for fugitive emissions, which most other states that I am aware of do not have allowable emissions or emissions limits for fugitive emissions unless you're a PSD source.
Okay. So, but a large part of the increase on the upper chart, or at least the highest, you have Chino 2023 fees, if PM10 added $180,000. That's, seems by far the highest fee pollutant.
Oh, absolutely. And that's primarily related to haulage.
Haulage, that's big. Does that mean like big trucks on the ground rumbling full of?
Haul trucks. Our whole operation is based on haul trucks moving or to the appropriate process.
Sure. Just and is there? I mean, it's just that's just sort of the nature of the business, or could those emissions be? Are those emissions particulate emissions? Could they be lowered at all, or is it just the way that the business is?
The allowable emissions are based on calculations where we use emission factors approved by the Bureau. And so we do look for ways to demonstrate a reduction in those emissions based on using dust suppressants in our mine. But we have to use emission factors that are approved by the Bureau. So even if we find that magic snake oil that's going to eliminate haulage dust, the Bureau has to agree to the use of that emission factor.
Thank you. Sorry, my computer, I need to reset it.
Yeah, we're aware.
Okay. So, but so a large part of that increase that Freeport might be seeing under these new provisions will be due to particulate emissions, correct?
Yes.
And that they haven't been paid because the rule has the way the rule currently is. Particulate emissions are not included in the fee schedule, correct?
That's correct.
So that'll be a big change for Freeport if this rule goes forward.
Absolutely. It increases our fees 8 times at Chino.
Okay. And I know, I guess we're running out of time, but now I think you started your testimony by saying that the NMMA doesn't believe that the Bureau has put forward enough information for them to assess the reasonableness of the proposal, correct?
Correct.
Now, reasonableness is somewhat of a subjective term, correct?
Perhaps, but we haven't seen any cost estimates or an estimate of the revenue that will be generated by the increase in fees. Until today, we didn't even hear a number of what the increased revenue would be from the Title V fees. And I think it's obvious that that $8 million does not include particulate matter.
Yeah, I think we're gonna have to.
Was that-
eliminate here, and we'll pick up in the morning at 9 o'clock.
Okay.
I'll ask for public comment session first, and then you can continue your cross-examination. Mr.
Okay, thank you. Thank you, Mr. Yes.